too much in love. They can't see the error of their ways. Blinded by the supernatural haze. Secrets some have taken to the grave. That's the game the devil plays. Use visions sent you on a mission from on high. Who's the zombie now? Everything you ever had is gone. Everything you thought was right is wrong. Broken hearts are left to carry on. Now you're both where you belong. Dreams, visions, it's a new religion of the lie. We're too young to die. Monty and the zombie killers. World is ended come July. In love, they can't see the folly of their ways. Burning with a dark infernal blaze. Doctrine that will put you in the grave. Let the demons out to play. Dreams, visions, giving you permission, taking life. And the zombie killers, world is ending come July. We're too young to die. Mommy and the zombie killers, it's all over come July. Who's the zombie now? Mommy.
Y'all, welcome to Difficult Research. Welcome everybody to Difficult Research. This channel is owned and operated by Kresha Kay Easton. And Kresha Kay is Kay Woodcock's daughter, JJ's aunt, Charles Vallow's niece, Lori Vallow's niece, and Tolly Ryan's cousin. It's a whole family tree involved here in this story. Trey says that Hookerella is there already. Yay, so she's there. They may have to drag her out. They got her there. Can y'all hear me? Is everything doing good? Everybody going? It's like, I was looking at some pictures earlier, and in the last trial, Lori looked more presentable. Her hair was more professional. And now she's got that Goldie Hawn laughing look going on. I think that's Goldie Hawn hair from like the 60s or 70s. You know, real fun, haha hair, beach hair. But I don't know whether that's a sign of her mental. Her hair may show her mental capacity. or which personality she's got on. So this morning, a document came down, and Joe Schmo posted it, so I was able to get it. So I thought before we started, they're already in the courtroom. She's there. I don't know if it started or not, but before I start posting tweets, we'll talk about this document that posted. And it was Lori had another request to get rid of her judges. I saw a comment earlier, and it said that that Lori wanted to see the judge manager. You see, she wrote this by hand. Excuse me. And so, can y'all see that? If I got that over there, we can see it. I'm gonna make it that a little bigger so y'all can see it, because the top part, let's see. Here's the title. It is Motion for Recusal of Chief Judge Green, Federal R Rule 4711. And it says here to explain what you want this court order to be about. And the judge may grant, deny, or change that request. So here it goes. Pursuant to Federal Rule 4711 of the United States Federal Rules of Defendant Request, that the Honorable Green Chief Judge of Mariposa County Superior Court immediately recuse herself in any further proceedings of the defendant. Ms. Lori Daybell, this motion is based on the following memorandum of points and authorities. And it's got DA, I think that's an example of Lori Daybell defendant, memorandum of points and authority. She crossed this out because she needed another piece of paper, I guess. Okay, let me go get the second page. Okay, I'll make that a little bigger for y'all. In case I don't read it right, I want y'all to know what it says. It says Federal Law Rule 4711 provides that the defendant's motion to request that Chief Judge of Mariposa County Superior Court immediately recuse herself from any further proceedings of the defendants. No punctuation at the end of any of that. On May 29th, 2025, Chief Judge Green violated the defense due process. She erased out something, I don't know what. Efficient notice of hearing. Due process requires that the defendant receive notice of a hearing, and Judge Green, Judge Justin Boreski, the state, and MCSO have failed to notify the defense, which is above parties. In fact, significant time for notification. This deprived the defense because of the breach in notification. The defendant was deprived of her advisory counsel as a whole for guidance. And as the defendant's advisory counsel was appointed by the judge, Justin Boreski, who cannot recall appointing them, December 6, 2024. The defendant was left intentionally. Okay, she says the defendant was left intentionally prepared by Chief Judge Green inappropriate hearing in the matter of the disqualification Judge Justin Boreski. The courtroom was dark and difficult for the defendant, but the defendant did answer her questions. When Judge Green was stating her decision, she blatantly, with disregard after the federal law USACA example 144 for disqualifying the judge, and misapplied Rule 10.1 for change of judge. A judge's decision is certainly contrary to the clearly established precedent if the state court applies a rule that contradicts the governing law under absolutely no impression rather than verbally or motion by Rule USCA something 144 does not allow or bias the prejudice to be allowed to remain in the presiding judge. In fact, quoting bias or prejudice of a judge. Whenever a party to any proceeding is in a district courtroom makes the file a timely and sufficient affidavit that the judge beforehand whom the matter is pending has a personal bias or prejudicial either against him or in favor of any adverse party, such judge shall proceed no further. Nowhere in the federal law does it state change of judge. Excuse me. Okay, here we go. Tennessee, Bostock, and she's got a number. I'm not going to read all that, but it says Reverend remanded if a judge had added, remodeled, updated, or distract from old sanctuary terms, they risk amending statutes outside of the legislature process. The legislative history may not be used to contradict an unambiguous text, and Congress does not alter the fundamental details of a regulatory scheme in a vague term or ancillary, let me get the next one. Lord of mercy. Provision, USA Constitution Amendment 14, unlawful motivation. There's unlawful motivation here. Furthermore, USCA 1519, destruction or alteration of falsificates of record report documents is prohibited by Judge Green. Did such a violation by misapplying and altering the defendant's affidavit, which is a document in which the Judge Green was investigating. Judge Green allowed the judge, Justin Bariski, to remain on the defendant's case, knowing the multitude of errors in his judiciary misconduct, misapplying governing laws, abuse of discretion, bias, prejudice, and violation of coded judge conduct 1, 2, and 3. Judge Green, Chief Judge, is currently in violation of. A judge must be vigilant and independent in reviewing motions of Judge Green's Chief Judge and Justin Just Bariski failed to judicially process in order to obtain a wrongful conviction, and it has violated double jeopardy when she has altered the statutes. Conclusion. The defendant therefore requests that Chief Judge Green of Mariposa County Superior Courts immediately recuse herself from further action in the defendant's cases, CR 2021, and it's the two cases, as above fact-finding justifies this specific request for abuse of discretion. One more page, y'all. We'll be done with this nonsense from this woman. Okay. Judge Commissioner, Arizona Court, Judge Green, Trina Kay and Rachel Mitchell, Attention to Lori Daybell Arizona. And this was denied. I want to say this right here all was denied. All that lawyer salad. I don't know what y'all are saying. I'm going to look at the chat. I was trying to read it all. So I know. Can you believe that? That's just crazy, isn't it? So let's get back over here and see. Oh, gosh. They're already gone. So I'm going to do that instead. See if Tracy's said something. Okay. So, wow. Are we getting started here and I hadn't finished telling what I knew? Okay, well, let's see. Let's see. Welcome, everybody. Detective's Daughter, Fancy Nancy, Northwest, Love Always, 124, Janelle Murphy, Kate. Yeah, that's an error. That was my error face. I saw it on the delay. So they must be getting about get ready. Yeah. Bewitches, I just want to share my appreciation for fellow supporters of Kresha and our combined pursuit of justice. Y'all, throughout the day, I have got Trace a thing if you want to donate for Trace's lunch, but later on, I might drop another link in the chat because we have someone who is one of our very hardworking moderators who is going through a very hard time. And so later on, I'm going to drop a link for that if anybody can help with that. I know everybody is strapped. Nobody should donate and make their family do without anything. But if you can donate, it's a good thing to donate to people who are. So I'm not going to act like I'm a fundraiser because other people watch our chats and they're like to find things to talk to us about. And so I think that we do try to take care of our own, and we do post links from time to time. But for the most part, the only thing that we really want people to do is to subscribe, maybe become a member. If you can like every video, liking every video really helps. If you can comment after a video is already up from it, if you can go back and comment, that helps with the algorithms. All these things will help because Kresha is trying to get information, and that's her main goal. And it's hard to wrap around have two main goals. So our main goal is that. So anyways, we'll be posting that link later. And also if anybody wants to help with Trace's lunch, I'll post that one more time later too. Okay. So let me see who else is on this. Take down this. That was interesting. Now she thought of every reason why she needed them judges to leave, but none of it made any sense. I don't know if that made any sense to y'all, but it didn't make any sense to me. So, I'm not sure what we're watching from. So, okay, so I can see that. If they start, we'll hear them. In the meantime, I'm going to post some tweets and we'll talk about those things. See what Trace is saying. She's saying that we're having a full moon. Ooh, y'all. Hey, Denise Gray, Buffalo 23 Butterfly, Jermaine. Uh-oh, here we got the FBI special agent is going to be doing some talking. Wow, exactly. Trace is ready to get on with this. Trace says, let's get this day started. The sooner we won't have to look at her or see her or hear her. You know, I really wanted to hear from her, and I'm tired of her now. Tired of hearing from her. Okay. Trace is saying that the Salt Lake City division works out of Boise, Idaho. Okay. Someone is saying that Northwest is saying that Nick Ballance is also involved in the Idaho 4 case. I imagine he is. Okay. Well, heck, are we having it? And I don't know. No. Okay, y'all, I'm going to put y'all on mute for a minute.
Explained at the beginning of his testimony.
We talked about this yesterday. We sort of previewed, foreshadowed Ray Hermosillo coming to take the stand and how much knowledge he has.
Yeah,
and
lot.
We asked the people watching in our poll, like, would this cause Lori Daybell to open the door to these prior murder convictions?
Mm-hmm.
The answer is no. And whether she got information or advice from her advisory council, that would be interesting to know. But
Yeah.
Ray Hermosillo is one of this small group, small police department in Rexburg, instrumental in really digging into the whereabouts of J.J. Vallow and Tylee Ryan, executing a search warrant, trying to find out what was going on because things weren't making sense, weren't lining up. Lori was lying at the time about where JJ was, saying he was back in Arizona with Melanie Gibb, her best friend. And I think Alex Cox had told authorities, Alex told them that he was with Kay Woodcock in Louisiana.
Right.
There were multiple stories that didn't make sense. Chad Daybell was there at that, door knock, and Chad Daybell said he didn't know Lori at all. At that point, when they were contacted, he was married, to Lori Daybell, and his wife. He had murdered his wife, Tammy Daybell, just a month prior. So Ray has so much context to it, and also walking the fine line and not giving all that away to the jury that's not supposed to know these details. Time they ever met in person, November 26, 2019. The next day is the search warrant. They're long gone, and they return back to they leave Idaho again. So it was all very suspicious at the time. We backtracked though to October in the surveillance video at the Rexburg storage unit. This is clear cut investigating by police, what they call good police work. Go into the home after executing the search warrant. You find this agreement with a business for a Rexburg storage unit. You go to that storage unit. You subpoena or whatnot, search warrant for the surveillance videos, October 1st, October 2nd, October 3rd.
Right.
And what do they see? They see video of Lori and Chad moving what looks to be a back seat, what looks to be a tire, and that's connected to the Jeep Wrangler. That's the suspect vehicle. And then also that's happening the same day of the shooting. And we know that license plate readers capture the Jeep with that license plate with no rear tire.
So, there was a lot made, obviously, kind of these October 1st, 2nd, and 3rd, right? And so if you're the jury, you got to kind of keep notes, keep track of all of this. We know the shooting was, October 2nd, right? So then you have this video, October 2nd. From your experience, you can get from Phoenix to Idaho in one day. Like, it's a long trip, but you can do it. This is where taking notes is very important as a juror, obviously. But these 3 days are really crucial to this case. This video was really important because you could call the manager of the storage unit to the stand, to have him describe, yeah, Lori came in one day, rented it, and then we saw them the day later, coming in and unloading some stuff, blah, blah, blah. But you have the video. The video speaks volumes, even though you look at it and you're like, oh, it doesn't show much other than they're removing a tire in a backseat of a Jeep. But you've already established why removing the back seat and why the tire not being on the back of the Jeep is so important to this case. Why would somebody take the back seat out of a Jeep? Why is the tinting so important? I mean, these are all the elements that have been presented up until this point. And then today you show that video from different angles, by the way. It wasn't just some grainy footage, 500 yards away. And you're like, I can't really tell who that is. Like, it's obvious at that point. You've got a clear look at the vehicle, the license plate. Now you could argue that the outlines of the individuals is not great, but way better than if you didn't have the video and you just had witness testimony of seeing this vehicle and these people there. I think for the jury, it holds more weight seeing it on camera in that capacity, and then having Trina interview Hermosillo about it and he provides even more detail about what we're seeing and why it's so important to this early October timeframe.
October 3rd, just as important. Alex Cox is back. He takes that tire back out of the storage unit. Takes the back seat out, and we know through the prosecution's argument, it's just for him to have a better shot on October 2nd. Brandon survived. He was not hit, but that was the whole point, according to the prosecution, of moving those pieces from that vehicle. Let's listen to Trina Kay ask Hermosillo about this storage unit.
The previous day, we'd seen Chad Daybell rolling the tire in. Here we see Alex Cox carrying it out.
Correct.
Short and sweet right there. And the bottom line is that this surveillance was being done since early November, but being able to get that storage unit video, crucial. And there's also documentation of Lori opening up that storage unit, registering for it. Yeah. And she was there in September. We know that J.J. Vallow's belongings were there. Tylee Ryan's belongings were there. They were murdered in September. The last time that Tylee Ryan was seen, September 8th, 2019, she's believed to be killed, buried in the ground September 9th. J.J. Vallow, last time he was seen, September 2nd, 2019, believed to be killed overnight or into the hours of September 23rd, 2019, both found on the Daybell property, and cell phone data of Alex Cox locating them there, basically Alex Cox's device on that property.
So go back to the tire, for instance. Okay, so, if you're, again, defense attorney, you could make an argument that it's not uncommon for people to remove a tire from a Jeep, and it's not uncommon for them to put the tire back on. What's unusual is that they remove a tire from the back of a Jeep, then drive across 3 states essentially, and then come back, put the tire back on. You would think you'd want the extra tire on your Jeep in case something happened. But again, that is to me, another glaring example of why, Lori representing herself is so bad, because this is another opportunity in cross-examination of Hermosillo where you could kind of dig in that and, again, downplay what Trina just showed. I mean, you could have kind of buffered that whole tire part of it, and maybe the jury goes, oh, okay, I guess that kind of makes sense, and they don't obsess over that video. But again, just the inexperience of it, like you said, there's so much more evidence that has not been presented in this case, rightfully so, because of the crossover with the other convictions. But man, I just, this is, if you're ever going back and doing kind of a one-on-one on how not to defend yourself, another prime example about not being able to take a note down and say, in my cross, I'm going to do this, this, this. Maybe there was another reason why she didn't, cross Hermosillo that we don't know about, but another missed opportunity for Lori there.
There's so much evidence that Hermosillo is able to bring to the table with his testimony. I mean, you see the photos of the rifles found in Alex Cox's garage, the scope, just, heavy duty firearms that, not everyone has in their garage. Yeah. Some people do, but I mean, with the context and the circumstances surrounding this case, the jury's probably looking at this and saying, whoa, now they see the Jeep suspect vehicle in their minds. Now they see Brandon Boudreaux fearing for his life on body camera video, or they, just picture him and what he was saying, and the Tesla, the bullet hole and all of that. It's clear that he is a gun owner. And the Google searches, the Homer J. Maximus Gmail account for long range shooting, ballistic charges, trajectory calculators, really like scientific terms for shooting, like in the weeds of it all, firearms, searching for a man shot in Gilbert, maps for Dan's window tinting,
Mhm.
the map to the Phelps Road address where Brandon Boudreaux was staying. I mean, it's all there under one Google account. Technology is just crazy how much it captures in this wide net of things. The jury has heard this. Lori Daybell does not have one cross-examined question.
Yeah, well, here's another opportunity. Okay, fine. Establish that Alex loved shooting guns. Okay, so he has weapons. He has lots of ammo. Is it weird that his apartment is empty? Okay, yeah, kind of. But um, people keep guns in their garage all the time. It's not illegal to have all these
And
weapons.
it's not her guns.
It's right. It's
She-
not my gun. Alex loved to hunt. Alex
So
loved
there's
to
an
shoot.
example.
Right. And if you're a shooter, of course you're going to shoot. You're going to search where to shoot, bullet drop, things like that. Is the timing of it bad because he's doing so close to the shooting attempt or the shooting at Brandon? Okay, yeah. But again, a good defense attorney argues that it's not uncommon what he did, right? A good defense attorney would say, yeah, most gun owners, they search for gun stuff all the time. They, of course they have multiple weapons and scopes and things like that. We heard about the residue and the
Down in the Jeep. Yeah.
right. If this jury, any of these jurors have a short-term memory, they're focused on what they just saw. And you just got 2 hours of damning testimony from a detective in Idaho. And you could have very easily, again, like I said, dampened it a little bit with just little questions like that. Like, hey, is it uncommon for gun owners to search about gun ranges? Is it uncommon for gun owners to have their weapons in? It's just, to me, it's textbook defense attorney 101. And I'm sure our panel would agree there that there's an opportunity, even if you don't go anywhere with your questioning, you at least cast some sort of doubt that whatever Alex was doing is not out of the norm, especially for a guy his age in Idaho, right? And anywhere really.
Eastern Idaho.
Yeah, I mean, it's
and
just,
from Arizona,
Arizona
who
as
always
well.
had an affinity for guns. But if you're Trina Kay, you say objection, speculation. Maybe even though Hermosillo is probably an expert on firearms, being that he's in law enforcement. But if Lori would have asked, you conducted a search warrant clothes or closets that were empty, you found other things, you found this agreement for the rental storage unit, did you find firearms in my garage? Things like that. There's definitely opportunity. We can't wait to talk to the panel about it. But yeah, very surprised that there was no choice to do cross-exam with him. But also now I'm not really surprised. I was shocked in the moment, but Hermosillo just has so much information. So with that said, we're heading into what's possibly closing arguments tomorrow afternoon. One more very key witness for the prosecution. And then the question, does Lori Daybell have anyone to testify for her on her behalf as far as a witness that she intends to call? I doubt it. We haven't seen one in the last trial, but you never know. This could be the Hail Mary. Is it her testifying on her own behalf? If things go as we foresee them, as far as the pattern is, closing arguments could be tomorrow afternoon. For now, make sure you hit the like button, hit the bell for notifications, and subscribe. See you tomorrow on The Record.
Okay, I'm back. I wasn't saying anything. Let me turn on the screen. I mean, I'll mess around and turn myself off. Woo! So it can't be long now. I got a phone call from my brother. I have to only answer phone for like two people, my mother and my brother. So I don't. See what Trace is saying. DJ Norman says, this is just some fun facts. Today is Upside Down 9/11 Day. Tomorrow is H.W. Bush's 101st birthday. He died on 11/17, Julian, 300, 2020. Okay, let me shut up. They haven't started the audio yet, I guess.
Jury in.
Yes, Your Honor. I would also like to include the letter from Tammy Lachik that she's unavailable to testify to be admitted for appellate purposes as well.
Is it marked?
I thought I had a copy. I will get a copy to you guys.
All right, we can mark it, and once it's marked, we'll take that up.
Okay.
No, that's a different one. Okay, let's bring the jury in. You want to get your witness ready?
Do you have one in your file? I never saw it. I know I printed it.
Jurors can be seated when they get to their chairs. All right, please be seated. The jury is present. The state can call its next witness.
State Call Special Agent Nicholas Ballance.
Sir, you're going to come up right here in front of my clerk and she'll swear you in.
Hello. Can you please spell your first and last name? Right hand, please. You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. Up the round the court reporter, up the wrist.
Go ahead.
Would you please introduce yourself to the jury?
Yes, my name is Nicholas Ballance. Last name spelled B-A-L-L-A-N-C-E, and I'm a special agent with the Federal Bureau of Investigation.
How long have you worked with the Federal Bureau of Investigations?
Since June of 2016.
What are the different jobs you've held while working there?
So I've served as a special agent as well as a period of time as a supervisory special agent. And currently I'm assigned to the Salt Lake City Division and work out of Boise, Idaho.
Now, prior to becoming a special agent with the FBI, did you have other law enforcement experience?
I did. I served as a deputy U.S. Marshal for 9 years prior to working for the FBI.
Now, as an agent with the FBI, have you been serving as a cast field asset?
Yes. So I'm a member of what's called the Cellular Analysis Survey Team, or CAST for short. And it's a specialty that utilizes cellular records as a part of investigations, trying to determine where a phone was whenever that has any significance to a criminal investigation.
How long have you been doing that?
I've been certified since October of 2019.
Okay. When you were working for the U.S. Marshals, did you do any work with cellular phones there?
I did. I was assigned to locating fugitives for a significant period of time with my career with the Marshal Service. And so I was able to use cell phone records to aid in locating fugitives successfully on several hundred occasions.
Can you tell us the education or training that you have to become a CAST member?
Yeah, so for the FBI with CAST, it starts with an application process where you would express interest in getting into the program. And then there's multiple trainings that you would go through before you're considered certified. It would start with our basic course, which is a 2-day course. During that course, you're looking at cellular theory and discussing the different cellular providers that, the major ones in the United States, and looking at records and putting those records onto a map. If you complete that successfully, you would go to our advanced course. In the advanced course, it's a little bit more in depth than basic, talking about some of the same topics, but you're also provided practical tests that you have to turn in, and then those tests are graded. At the conclusion of the advanced course, if you complete that successfully, you would go on to our what's called CIRA. It's a 3-day course, or was when I went through it, and it's our critical incident readiness exercise. So as a part of that training, there's no instruction. You're just presented with problems and practical scenarios that you would have to go through, map out records, and reach a conclusion. And it's supposed to simulate like a command post style environment where you're getting information rapidly as a part of the training in a short duration. If you complete that course, you would go to our 4-week certification, and that is extensive classroom lecture that includes radio frequency professors that are teaching about in the field of radio frequency. We also get instruction from the major providers in the United States for the cellular industry, to include their engineers as well as their subpoena compliance personnel. On top of that, we have a practical exercise that's assigned to us that we have to work from beginning to end, that culminates into testifying at the end and presenting a report and being challenged on that report, both by prosecution and defense that are simulated role players. At the conclusion of all of that, you would be considered certified as a member of CAST.
Do you have any annual recertification types of trainings to remain active as a CAST member?
Yes, so we have to complete a certain number of record analysis during that each year. And on top of that, we have a one-week certification conference that we attend each year that includes updates from the major providers in the cellular industry, as well as updates when it comes to the field of cellular technology from radio frequency engineers. And that's each year that you're in the program.
Okay. Have you previously testified as an expert in the area of cellular analysis?
Yes, ma'am, I have.
And as a CAST member?
Yes.
In this case, were you asked by the Gilbert Police Department to analyze some cell phone records?
I was.
Were you provided with cell phone records for a Lori Vallow for a 480-489-4652?
Yes, ma'am, I was.
Were you provided with cell phone records for an Alexander Cox for the phone number 480-351-9120?
Yes, ma'am, I was.
And were you provided with track phone records for a cell phone purchased from a Walmart in Idaho Falls, Idaho, with a phone number of 304-960-5998?
For that one, I was from track phone as well as from Verizon.
Okay. Were you also asked to include or analyze some Google historical location data associated with a Google account, homerjmaximus@gmail.com?
Yes, ma'am, I was.
Can you tell us what is historical location data?
Yeah, so Google offers a range of services with their products, and one of those being location history. So if you were to opt into location history on your Google account, what that would do is it would Google would maintain different locations that the device that's reporting that location information where it was historically. So if the user has that active, it would depend on the specific phone that was relaying that information to Google. So as an example, if I have a Google account and I have 3 different phones, I could access that Google account from all 3 of those phones, but if only one of them I've opted into location services, then any of the location history that Google maintained would only be associated with that specific phone for the location of where that phone was.
But the data overall from Google, they might provide information from all the devices though, in terms of like searches that were done.
Correct. And again, it depends on how the user has their account set up with what information is going to be maintained by Google, specific to the many different products that Google has and offers to a user.
Okay. Were you asked to look at a specific time frame?
I was, specifically late September into early October in this case.
Did you create a report to help explain your process and explain the analysis of these cell phone records and these Google records?
Yes, ma'am, I did.
And because it's on a thumb drive, I'm just gonna share the first page. And it's 189, if I can have my paralegal. Does that look like your report that you created in response to the request by Gilbert Police Department?
Yes, ma'am, it does.
State will move to admit Exhibit 189.
Any objection to 189? All right, 189 submitted.
If I may publish. So starting on the first page of your report here, what did you include here for us to understand as part of your analysis and review of devices and phones?
So this is basically the cover sheet that I would put on all my reports, and it's showing the specific accounts that I did analysis for. So in this case, the 3 telephone numbers are listed at the top, one ending 4652, one ending 9120, and one ending 5998. Additionally, in this case, since I analyzed Google location history, the account that Google location history was associated with is listed. That's the homerjmaximus@gmail.com. The specific dates that I conducted analysis for, which in this case were September 25th, 2019 through October 3rd of 2019. The date that I completed my report, case number associated with the report with the FBI, and then my name.
Now, you were provided these records that from the Gilbert Police Department for these cell phone numbers. Did that include information like subscriber information?
It did, yes, ma'am.
So the 480, 489, 4652, when you reviewed those cell phone records from Verizon, did that show subscriber of Lori Vallow?
So it did not. It was subscribed through TrackPhone. So the name was not Lori Vallow, but there was an email address on the subscriber sheet associated with her.
Okay. The 480-351-9120, was that as a Verizon record? Did you receive the Verizon or the TrackPhone records?
I did, and that was subscribed to Alex Cox.
Okay. And the 304-960-5998, was that Verizon or TrackPhone?
So it was subscribed through TrackPhone.
When we're talking about TrackPhone and Verizon, and you talked about sort of major companies, how do those all interrelate?
Yeah, so when you're looking at cellular providers, you have 2 different categories looking at kind of from a wide perspective. You have companies that have infrastructure, like cellular towers that they maintain throughout the region that they provide service to. So Verizon is one of those companies. They have cell phone towers throughout the United States. When you're talking about TrackPhone, They're a mobile virtual network operator, which basically means that they don't have cell phone towers, so they have to lease space with another network in order to provide service to their customers. So TracFone, specifically in this instance, was utilizing Verizon for the number ending 5998 to provide service to that customer.
Okay. And the Google records that you were provided for the Homer J. Maximus at gmail.com, did that provide subscriber information?
It did, and that was associated with Alex Cox.
The second page of your report, what is this telling us about in terms of your analysis and explanation?
Yeah, this is basically just explaining the methodology of how I created this report and the process that goes into place in order to take records from a provider like Verizon and then put those records onto a map. Again, this is the methodology.
Third page here, one of the things that when you are looking at most or all of these cell phone records, were you provided the times in universal time, UTC time?
Yeah, so depending on the provider or the company that's providing records, kind of the biggest difference that you'll see in the different records types is a lot of them will provide records in different time formats. So specific to Google, they provide their records in what's called UTC time. And so that's just a time standard to where if you wanted to do the conversion and see what time that was in the area where you're at, you would have to do a conversion depending on what location you're in order to get it into the local time.
So when you were mapping these cell phone records and these Google devices, converting them for the purpose of your report into the local time, either Arizona or Idaho?
Yes, ma'am, that's correct.
So while we're going through your report, all either Idaho or Arizona, depending on where we're looking at.
Correct. And the report will reflect the times as well.
What do we see here and what is this explaining to us?
So just to talk briefly about how cell phones work and kind of how we're utilizing the methodology that I spoke of to map and estimate where a phone was historically. One of the things that we look at is how far a cell phone tower provides coverage to. That's usually one of the major questions. So typically a cell phone tower density map is going to look very similar to a population density map. So here we're looking at the city of Phoenix, and as you can see, there's a couple of towers in downtown Phoenix and in the urban areas of Phoenix. Those towers are going to provide coverage to a much smaller area due to the number of users that are needing to access a particular carrier. As you get more to the rural areas, you can see that those towers are more spread out, and towers in rural areas are going to have a larger coverage area just because there's not as many people in those locations.
And what is this page 5 reflecting?
This is just an example of what cell towers look like, not to insult anyone's intelligence, but if you look at the second tower from the left, traditionally back in the day, that's what we saw cell phone towers look like. Now there's more of a push to make them more aesthetically pleasing. So as you can see, like with the cactus, that's actually a cell phone tower, trying to disguise it so it's not looking like you have all this different metal around an area.
Page 6, what is this explanation for us in terms of what we've seen for your analysis?
Sure. So whenever I'm mapping a estimated location of where a phone was, I'm looking at a traditional tower has 3 sides. So if you look at the graphic on the left, you're looking at the tower itself, and then there's 3 sets of antenna facing 3 different directions on the tower. So if you look at the graphic on the right, that's looking from the top down. And so the cell tower is pushing out coverage kind of 360 degrees. But what providers do is they put different sets of antenna on that tower in order to optimize their network and divide that coverage up into different sectors. So whenever I'm looking at a call detail record and I'm seeing a particular call that might be of interest to an investigation, I would then look at the tower and sector that was used. So that way I can plot that tower onto a map and I can see what direction from the tower that specific sector is providing coverage to. So again, this is a traditional tower, but it's divided into 3 equal parts with sector 1, 2, and 3. And in my tower list, I'm able to see the tower that was used, and I'm able to see what's called an azimuth, which if you're not familiar with that, it's basically just showing me what the center line of a sector, what direction it is coming from the tower. So if you're looking at this particular graphic on the right, you can't see the 0, but it starts with 0 and goes all the way around to 360 degrees like a compass. So the center line of sector 1, that azimuth would be 0 degrees. Same thing with, if you look at sector 2, the azimuth on sector 2 would be 120 degrees. So that azimuth allows me to estimate the location of where a phone was in relation to where that tower is.
All right, so this information of the tower sectors and azimuth, was that included with the cell phone records that were provided to you for those 3 phone numbers?
So it's included in a different file, but all of the different cellular providers that have towers throughout the United States, they have what's called a tower list that they update pretty regularly, at least every few months or quarterly. So in conjunction with the call detail records that show me who was called, at what date and time, what tower was used, I can marry that up with the tower list, and then I can have an estimate of where that phone was whenever it had that specific interaction with the network.
So someone like Verizon will provide you with, for that specific phone number, calls made and what tower they're using, and then you're able to then get the location of that tower from Verizon to map it.
Correct. If you think about, and everybody can still do this online, but back in the day when you had your cell phone, each billing cycle, you would get that bill in the mail. It would be fairly thick because it included all the different calls that were made on that account. And so the call detail records are very similar to that. We can see the date and time. We can see that it was a voice call. We can see the direction, if it's incoming or if it's outgoing. We can see the associated number. But what you don't see on that bill is the tower information. So the call detail records that we obtain as law enforcement, they include those columns, and those columns allow me to know at a specific date and time, this tower and sector was used. And then I can marry that up with the tower list and provide that estimated location of where a phone was.
So what do we see here on page 7? We have a legend for us.
Yeah, so this is depicting how I'm going to display different pieces of information on my report. So starting at the top, you're looking at Verizon towers are going to be represented with red dots. That's going to be important because when I talked about before, where you're looking at the density of Phoenix and towers are going to provide coverage to a smaller footprint in an urban area where there's towers close by, it's important to note where other towers are in relation to the one used, because typically what we see is that a tower provides coverage to the next tower. So that's what allows me to estimate the coverage area of a tower and sector that was used for a particular interaction. Next, we see how we would represent the tower and sector. So the blue, black, and the red are going to be the 3 different phones in this case. So if you look at the blue, that's representative of a tower, and then the direction from the tower that that sector is facing. So the blue graphics are going to represent the phone number ending 4652. Black will represent 9120. And red will be representing 5998. Additionally, you see to the right, the call information box. So whenever a phone has an interaction, you have that line in a call detail record, just like I talked about on the phone bill. I'm going to represent that particular call with the information that's provided from the carrier here. So you'll see the tower information at the top, the target number that is associated with, so what record that particular line came from, what account, the date and time, direction of the call, duration of the call, type of the transaction, the word I mentioned earlier, azimuth, which gives us the direction from the tower that that specific interaction took place, and then the associated number. And then additionally to the left, you'll see a call information box where there's data interactions between a phone and a network. There's less information there, but you'll at least see the date and time and the direction from the tower that that sector faces.
Okay. So these are things we will see in the mapping that you did for this case.
Yes, ma'am, that's correct. So I spoke about how I would map cellular records. This is a legend to show how I would map Google location information. So I talked a little bit about Google derives their location information from different data sets. And so Google can estimate a location of a device by locating it via the GPS chip within the phone. It can do it via Wi-Fi as well as cellular. Specific to this case, we're only going to talk about locations that were derived via GPS and Wi-Fi. And so that's the icon that will be representative of that specific location line in the Google return. You also see a margin of error, which is showing Google in each specific line where they locate a device, they provide the estimated margin of error associated with that specific locate. So there will be a circle around the specific locate on the map. And then also, depending on if it's only a few, if there are a number of records on the map, it would be very difficult to read, to put every single information box associated with each line.
Apartment 175 and apartment 107,
Yes, ma'am, that's correct.
and then a self-storage plus on Airport Road in Rexburg, Idaho,
Yes, ma'am, correct.
and then a Walmart at Idaho Falls, Idaho,
Yes, ma'am.
and then also a Melanie Boudreaux residence in Gilbert, Arizona.
Yes, ma'am.
So first map Can you tell us what we're seeing here and explain everything?
Yeah, so these maps are just laying out where the locations of interest were that was provided by the investigative team. And so whenever I have like this is zoomed out, a decent ways to incorporate both the address down in Idaho Falls and the addresses that are in Rexburg. And so there's a box to the side that's basically showing a zoomed in view of the apartment complex that includes the addresses for Alex Cox and Lori Vallow's apartments.
All right, so the Idaho Falls WM at the bottom is that Walmart, and then you can see the storage unit and then the zoomed out of the 2 apartments in Rexburg, Idaho.
Yes, ma'am, that's correct.
Is this just a closer up single page of that?
Yes, ma'am, it is.
All right, what do we see here on page 12?
So the previous 2 pages were up in Idaho. This is down in the area of Gilbert, Arizona. So this includes 2 addresses, one for Brandon Boudreaux and one for Melanie Boudreaux.
Okay. And so we see that with the bluish purple and the pinky color. The homerjmaximus@gmail.com records that were obtained by law enforcement. Did those homerjmaximus@gmail.com Google records show that the records were tied to an MEID number?
Yes, so that's mobile. The IMEI is equivalent. Time no. In this case is synonymous with the IMEI or the hardware of a phone. So that identifies a device. So what I can do with that number is I can then take that to different cellular providers and determine whether that number has ever shown up on their network and whether they can associate that number to an actual telephone number.
And was that MEID number that we see here on page 13?
Pay the and show that 598
8 track phone was purchased at a Walmart at Idaho Falls, Idaho?
Yes, correct.
And when does it show that being purchased?
So it shows it being purchased on September the 25th, 2019 at approximately 7:10 p.m.
Okay. And does it show a store number of 5494?
Yes, ma'am, it does.
So when we get to page 16, we start to see those icons for the Wi-Fi. So we're now talking about the 9120 number.
Yes. And so being this is the first map, I'll explain it a little bit more thoroughly than the others. But as you can see at the top, you're going to see what this record represents, Google location history associated with the homerjmaximus@gmail.com account. And then basically I'm putting the bookends of the times at the top. So these records are from September 25th, 2019, starting at 7:07 p.m. and continuing through 7:16 p.m. There's 6 of them. So you see a summary box. They're all sourced or derived from Wi-Fi. And of the 6, the margin of error is between 16 and 100 meters, which you can see with the black circles. Obviously, the smaller one there in the middle is closer to the 16 meters, whereas the larger ones are at 100 meters margin of error. And they are consistent with the device 9120 reporting its location to Google as being at the Walmart on Utah Avenue in Idaho Falls during that time period.
So basically the 9120 cell phone is reading Wi-Fi signals around it.
Yes, and one thing I didn't explain earlier is that whenever a location is derived from Wi-Fi, it doesn't mean the device was connected to specific Wi-Fi points. It just needed to be in range of those Wi-Fi points and see it. So if you've ever experienced where you're going through the airport or you're looking at your location on Google Maps and it says turn on Wi-Fi to get a more accurate or precise location, it's because Google has a pretty vast database of knowing where Wi-Fi access points are throughout the United States. And so if I'm sitting here and I'm close to a McDonald's that has a Wi-Fi hotspot on it, and my phone sees that Wi-Fi hotspot, I don't need to connect to it for Google to know that that specific Wi-Fi hotspot is located at a specific address. And then Google can estimate my location based on my phone seeing those different Wi-Fi access points.
So in this case, we see the phone that's subscribed to Alex Cox, that's using his Google account, is at this Walmart in Idaho Falls between 7:07 p.m. and 7:16 p.m.
Correct. I would say it's consistent with being at that Walmart.
And so we had seen in the prior slide that the track phone, the 304-960-5958 number, was purchased around 7:10 p.m.
Yes, ma'am, that's correct.
So this phone associated to Alex Cox is utilizing or is reading the Wi-Fi around it and providing this data around the same time when that track phone, the 304 number, is being purchased at that Walmart.
Yes, ma'am, correct.
What does this next map show us, page 17?
So again, I'll speak a little bit more thoroughly on this one since it's the first time I'm showing a tower and sector being represented on my report. So again, at the top, you see the tower interactions and the number associated with it is going to be the number ending 4652. The date, again, I usually book into this unless everything occurs within that same minute, but we're looking at September the 25th, 2019 at 7:08 p.m. And we see 2 incoming calls that occur, and 4652 is utilizing a tower and sector that is in close proximity to that same Walmart on Utah Avenue.
Now, when we are looking at this cell tower usage, do you whether or not that phone has to be within that azimuth?
Sure. So whenever you're talking about radio frequency propagation and what the footprint of a tower's coverage area looks like, it's definitely not best represented by lines in the sand. It's more representative of like a cloud, to where if you look at the lights in this courtroom, you have the light that's shining up in the corner there, and you can see it pretty bright. As you get farther down the wall, light starts to dissipate and starts to get more and more dim. There's not just a line up there on the wall where the light ends. Radio frequency can be looked at the same way. So that signal is going to dissipate as it gets farther and farther away from the area where it's meant to provide coverage to. And so when you're looking at how I'm depicting this on a map, I'm showing the sector based on the azimuth on both sides of what the endpoints of that sector look like. But I would expect to see a phone that is in close proximity to that line potentially still be on a sector, even if it's not within that parameter. All that to say that when I look at this particular graphic, based on my training experience, I would say that our sector is providing coverage to the Walmart due to the close proximity.
So what we can say is that the 4652 number associated to Lori Vallow is utilizing a tower in the area of the Walmart within a couple minutes of that track phone, the 304 number being purchased at that Walmart.
Correct, 2 minutes prior.
And in fact, is one of her phone calls last about 10 minutes?
Yes, ma'am, correct.
So through the time of that purchase even.
Yes, ma'am. I would just point out that whenever, if you go back, sorry, to that page, whenever I'm looking at a tower interaction, whenever that phone is interacting with the network, we're looking at whenever that phone initiates that specific interaction. And so during that 10 minutes of time, I can't tell you specific to Verizon where that phone was located. I can only tell you at 7:08 and 31 seconds, it was utilizing that tower and sector. But let's say, for instance, that phone were to move out of the area, that would not be able to be determined by the records that I have.
That phone number that is being called at that time as well, are you familiar with that phone number?
I am, yes, ma'am.
The 480-266-8587, whose phone number is that associated to?
I had that associated with Melanie Boudreaux.
So at the time that Alex Cox's phone is in the Walmart, at the time that that track phone is being purchased, Lori Vallow is speaking with Melanie Boudreaux using a cell tower in the area of that Walmart as well.
I wouldn't be able to say who was speaking with who. I could only say that the phone number 4652 received an incoming call from 8587, and then who those numbers are associated with.
So at the time that the phone associated to Lori Vallow is using a cell tower in the area of the Walmart, she is receiving a call from the phone associated to Melanie Boudreaux.
Yes, ma'am.
And that's September 25th.
Yes, ma'am, correct.
What do we see then when we get to page 18 here?
This is looking at the first mappable record for the number ending 5998 on September the 26th at approximately 11:31 p.m., making an outbound call utilizing a tower and sector that provides coverage to both Lori and Alex's residences.
All right, so this is the phone that was purchased at the Walmart that we were just discussing in the prior maps.
Yes, ma'am, correct.
So on the 25th, that phone is purchased from the Walmart, where we see cell phones associated to Alex Cox and Lori Vallow being there or near there at the time of the purchase. And now we see the phone being activated.
So I wouldn't be able to say specific to whether that's the actual activation, but that is a call, I believe, to a number associated with either Verizon or Track Phone. But
we do know from the prior records that the phone was activated on the 26th, though.
Correct. I know from records, and I don't know if it was one that we showed in here, but I know that it's first started being used on the 26th.
And I think if we were looking at page 13, we showed the first data connection time was September 26th at 7:58 p.m. UTC.
Correct. That was when it connected to Google, if I'm recalling correctly. And so the phone wouldn't necessarily have to have Verizon service to connect to Google. It could have done that via Wi-Fi or some other method to connect to Google the first time.
So what we're seeing here then is something potentially different, where we now know this phone, the 304, is actually using cell towers and able to now make outgoing calls.
Correct.
And it's using a tower that would be consistent with covering the apartments for Lori Vallow and Alex Cox.
Yes, ma'am.
All right, what do we see here? We're still on September 26th and
Yeah.
around the 2 minutes from the previous map.
Yeah, so this is just a record in close proximity in time, showing a Google location record where the number ending 9120 was reporting its location to Google as consistent with being at Alex Cox's apartment. That's on September the 26th, 2019 at 11:33 p.m.
So we see the track phone from Walmart using a cell tower at 11:31. And then we see Alex Cox's cell phone, I guess, reading Wi-Fi at 11:33.
It's reporting its location to Google at 11:33.
You've jumped ahead a couple days. So we had September 26th. Now we're looking at September 30th.
Yes, ma'am.
What are you depicting here, and what did you find from the records that you reviewed?
So this is showing on September the 30th, 2019, between 4:32 and 4:37 p.m. Starting at 4:32, the number ending 9120 is reporting its location to Google, consistent as being at Alex Cox's apartment. And then showing movement at 4:34, and by 4:36, the 9120 phone is reporting its location to Google, consistent with being at Lori Vallow's apartment.
And so that's where, when we're looking at that R15, that's the margin of error of 15 meters.
Yes, ma'am, correct.
So the phone is within 15 meters of being at Lori Vallow's.
That's what Google is reporting.
We're still at September 30th here.
Yes, ma'am. And so that's looking at the remainder of the day, going from September the 30th, from 4:38 p.m. all the way to 11:59 p.m. Approximately 94 different records, all consistent with the number ending 9120, reporting its location to Google as being in the area of Lori Vallow's apartment.
And so here, because you had so many Wi-Fi readings that are reportings, you just put that there were 94, well, I guess 93 Wi-Fi and 1 GPS.
Yeah, and basically what I was trying to look at is whether there were any instances that indicated that that device went back to Alex Cox's apartment, and I was unable to find any.
So we're on page 22. What are we now seeing here?
So again, at the top, I'm basically bookending the dates and times. So we're looking at two different uses of the Verizon network by the number ending 5998. The first one is on September the 30th at approximately 12:34 p.m., utilizing a tower and sector that's up in Rexburg, Idaho. And then the next use that we see is October the 1st, 2019, the same phone number ending 5998, using a tower and sector consistent with being down in Arizona.
So the 12:34 p.m., that's Idaho time.
That's correct.
So when we looked at the movement, that would be before we saw the 9120 phone associated to Alex Cox moving from Alex Cox's apartment to Lori Vallow's.
Correct. And I would point out that this is not showing that at 12:34 that device began heading south towards Arizona. That's just the record that I had at 12:34. So there was no other use between those two time periods, so I'm not able to estimate where that phone was during that time period.
Okay. So we know at 12:34 p.m. on September 30th, that track phone, the 304 number, is still in Rexburg, Idaho, receiving an incoming call at that time.
Yes, ma'am.
So let's talk about that call. Do you recognize that phone number, the 515-402-0143 number?
I do.
And that is a call being made to this Walmart. By whom?
So I have that number associated with Chad Daybell.
So Chad phone is calling this Walmart track phone that just was activated a couple days earlier. October 1st. See on this map that you have AM. So this is Arizona time.
Yes, ma'am. Correct.
And so at this point at 9:19 a.m. on October 1st, that track phone from Walmart in Idaho Falls is now using a cell tower in Arizona.
Yes, ma'am.
And do we have it? We've seen the prior box showed an incoming call. When we talk about outgoing, does that mean this track phone is making that phone call to someone?
It does.
And so who is this track phone calling at 9:19 a.m. on October 1st?
It's the same number from the previous Chad Daybell, the number ending 0143.
So map 23, what do we see here?
So since this is going back and forth between Arizona and Idaho, I tried to put the map of the specific state that it represents, just in case you're not familiar with a specific area. This is showing on October the 1st, 2019, between 2:56 p.m. and 2:59 p.m. movement of the 9120 phone, because it's reporting its location to Google as being 3 different locations along East Center Street in Rexburg, Idaho.
This. All right, so October 1st, 2:56 p.m. to 2:59 p.m. Idaho time, we see the 480-351 number associated to Alex Cox. His Google is reporting this location data.
Yes, ma'am.
Meanwhile, we see the track phone from the Walmart that also has been associated to the Homer J. Maximus Google account is in Arizona.
Correct.
What do we see in this next map?
So this is looking at October the 1st, 2019, from 3:10 p.m. to 3:36 p.m. The 9120 phone is reporting its location to Google, consistent with being in the area of the Self-Storage Plus in Rexburg, Idaho.
So did you ever view video from the self-storage unit from this time period of October 1st, 2nd, and 3rd?
I believe I did, but it's been some time since then.
You show some records there, so you were provided at least with information. Let me ask you this. Were you provided with information that Lori Vallow had rented a storage unit at the Rexburg, Idaho?
Was that you can see on the that picture of the report.
And so when we're talking about the relevance of this, it was one of the locations in the original map that you were asked to look at during this time period?
Yes, ma'am. Correct.
So to understand what we have going on October 1st, we have Lori Vallow renting a storage unit in Rexburg, Idaho at this time on October 1st.
That's based on the receipt that I was provided.
Okay.
That would be the
And
extent of my knowledge.
At the same time, you have the cell phone associated to Alex Cox reporting Wi-Fi and GPS location data to the Google at the same time that this is all, that Lori Vallow is renting this unit.
Yes, ma'am, correct.
What do we see then in map number 25?
So this is close to the same time period as the page before, October the 1st, 2019 at 3:24 p.m. And this is showing use of the 4652 phone for 2 incoming calls, utilizing a tower and sector in Rexburg, Idaho, that would provide coverage to the area of the self-storage plus.
All right, so the previous map was about 3:10 to 3:36. So this is in that time period towards the end of it. The phone number we're talking about is the one that we've associated to Lori Vallow.
Yes, ma'am, correct.
And so when we see this cell tower use, is that a cell tower that would be consistent with providing coverage to the storage unit?
Yes, correct. And I say that because I'm familiar with the area and familiar with the terrain. And that's why I'm able to say that that tower and sector would provide coverage to that general area.
Okay. Now, when we're looking at this time, we see 3:24 p.m. Idaho time. What would that be Arizona time?
So Arizona is 1 hour behind, so that'd be about 2:24.
So at 2:24 Arizona time, this 480-266-8587 number is calling Lori Vallow's cell phone.
Correct.
And is that 480-266-8587 number the one you told us is associated to Melanie Boudreaux?
Yes, ma'am.
And so all of this is going on while we also see Alex Cox's cell phone providing that GPS and Wi-Fi data for being in the area of that storage unit as well.
Yes, ma'am.
So we're continuing on October 1st in this, still in Idaho?
Yes, ma'am. This is October 1st at 5:17 p.m. Again, the 9120 phone is reporting its location to Google, consistent with being in the area of the Rexburg, Idaho temple.
So we've been talking about October 1st. When we get to page 27, are we now on October 2nd?
Yes, ma'am.
So we had some cell phone or one cell tower use by that Walmart track phone on October 1st. Are you now reflecting cell tower usage by that track phone on October 2nd?
Yes, ma'am. So this is showing records associated with the 5998 number between October 2nd, between 7:02 and 7:20. Starting over on the left side using a tower, 2 different sectors on a tower, 7:02 to 7:09 on the sector facing west. And then we see a shift at about 7:17 to utilization of the tower facing north-northeast, sector facing north-northeast, excuse me. Then by 7:19, we start to see use of a tower and sector that's just east of that location. My examination of these records, I would say it's consistent with that device likely moving eastbound.
Okay. So from 7:02 to about 7:18, the Walmart track phone from Idaho Falls, Idaho, is using cell towers in the area of Melanie Boudreaux's residence.
Yes, ma'am, that's correct.
And then after 7:18, that cell phone, track phone from Walmart in Idaho Falls, Idaho is now utilizing a cell tower closer to Brandon Boudreaux's residence.
Yes, ma'am.
Is this a continuation of that morning reflecting that Walmart track phone?
Yes, ma'am, it is.
Can you tell us what this map is showing us?
So this is showing the same thing, the 5998 phone on October 2nd between 7:22 and 7:24. utilizing two different towers, and specifically the tower more in the middle of the page, two different sectors on that tower, consistent with being in the area of Brandon Boudreaux's residence.
So from 722 to 724, we're seeing cell tower use from that Walmart track phone, consistent with it being in the area of Brandon Boudreaux's residence.
Yes, ma'am.
And this is the same cell phone we're talking about that has been associated to Alexander Cox's homerjmaximus@gmail.com Google account.
Yes, ma'am.
So we went back to Idaho in this photo.
Yes, ma'am. So this is back in Idaho in Rexburg, and this is showing on October the 2nd, 2019 at 8:02 in the morning, Arizona time, which would have been 9:02 up in Idaho. But there is an outbound call made from the number ending 9120 to the number ending 4652. This call is a little bit over 23 minutes. And during the call, both phones are using the same tower and sector, both of which provide coverage to the apartment complex that had Lori Vallow and Alex Cox's units in it.
So basically we have the cell phone associated to Alex Cox, the 480-351-9120, calling the cell phone associated to Lori Vallow, 480-489-4652 at 9:02 Idaho time.
Yes, ma'am. Correct.
8:02 Arizona time.
Yes, ma'am.
And that call you said was not quite 24 minutes.
Approximately 23 minutes and 34 seconds.
While that is going on at 8:02 a.m., we've seen just a little earlier that the Walmart track phone from Idaho Falls is now utilizing cell towers in Gilbert, Arizona.
Yes, ma'am.
Now, during this call, did you have any Wi-Fi or GPS location data for that Homer J. Maximus Google account associated to that 351 number?
Yes, ma'am. There was one at 9 o'clock and 9:10, both consistent with the 9120 phone being in the area of Lori Vallow's apartment. But I'll also add to that, that entire day, that phone only reported being in the area of Lori Vallow's apartment, not Alex Cox's.
So basically, we continued what we saw from the day before, other than we saw, well, let me say this. So we saw the phone going over to the phone being the phone number associated to Alex Cox, the 9120 on the 30th, move over to Lori Vallow's apartment.
Consistent with that, yes, ma'am.
And then we saw location data provided to Google for that same phone, the 9120, moving at some point away from Lori Vallow's residence, going to, for instance, on the first, an area near the self-storage unit,
Yes, ma'am.
going to the temple,
Yes, ma'am.
and then returning back to Lori Vallow's apartment.
Yes, ma'am.
And then we have on the 2nd in the morning, this phone call between Lori Vallow's cell phone, the one associated with her, and Alex Cox's cell phone, or the one associated with them.
Yes, ma'am.
So as we get to slide 30, what are we reviewing here now? Where are we at?
So we're back in Arizona looking at records for 5998. Here we're looking at October 2nd between 8:39 and 9:16 a.m. And the 5998 phone is utilizing a tower and sector in the general area of Brandon Boudreaux's residence. And there's 3 outgoing calls, 2 incoming calls, all from the number ending 0143.
Is that the phone that has been associated, that you are aware of, associated to Chad Daybell?
Yes, ma'am.
And Chad Daybell is Lori Vallow's husband?
I'm not sure if she was at the time, but
Correct.
that's my understanding now.
So when we look at this phone, were you aware that the shooting of Brandon Boudreaux at 3875 East Phelps Street occurred around 9:13 or so in the morning?
It's been a period of time. I know it was sometime around then, but I wasn't sure the exact time.
So in the time period leading up to right around that 9:13 time, that's track phone from Idaho Falls Walmart is utilizing cell towers in Gilbert, Arizona that would cover the area of Brandon Boudreaux's home at 3875 East Phelps Street.
Yes, ma'am.
What do we see here on map 31?
So here we see starting on October the 2nd at 9:17 in the morning, use of a tower and sector facing north on that tower, showing use of the 5998 phone, and that tower and sector would provide coverage to the area of Brandon Boudreaux's residence. Then we see a shift starting at 9:19 to a sector that's facing more southeast, and continuing through 9:22, we see use of a different tower southeast of that location, consistent with that device moving southeast out of the area.
So if we had received information that the shooter in this case moved south to Pecos Road that we see here in the map and then headed away, is that sort of the same direction that we're talking about? The cell phone is using towers in that same direction.
I would say it's consistent with that movement.
And then we see the cell tower as the morning moves on, going further south and east.
Yes, ma'am. I would just say southeast, based on the tower locations that I was looking at in the records.
And obviously, you're not able to tell us exactly where this cell phone is because it doesn't have the Wi-Fi or GPS location data being reported.
Correct. I'm only estimating locations based on the records that I have, and the records that I have are going to dictate how precise I can be with those estimated locations.
So here we know the cell towers that are being utilized by this phone during the morning there.
Yes, ma'am.
And again, when we look at these phone calls, incoming and outgoing, were all of them being made or received by that same phone number associated to Chad Daybell? So
here we're only looking at one call, but yes, that call is to the 0143 and it's an outgoing call to that number.
So we have cell towers that are reporting, and then we also have phone calls starting. So the first we see after the 9:15 one from the prior page is at 9:22, which is an outgoing call to Chad Daybell's cell phone.
Yes, ma'am.
What do we see now here on page 32?
So this is looking at Google location information on October the 2nd, 2019, between 9:02 and 9:34. The 9120 phone is reporting its location to Google, consistent with being at Lori Vallow's apartment.
Okay. And you've told us that sort of this has been at any time from the 30th when you documented that cell phone associated to Alex Cox, the 9120, moving from Alex Cox's apartment over to Lori Vallow's. From September 30th through this time at 9:34 a.m. on October 2nd, did you ever see the phone move back to Alex Cox's apartment?
No, ma'am, I did not.
Slide 33.
So this is back in Idaho, showing the usage of the number ending 4652 on October the 2nd from 8:50 in the morning to 9:46 in the morning, sticking with Arizona time based on the fact that there was an incident that occurred in Arizona. So between 8:50 and 9:45, there's 5 instances where that phone is on the network and utilizing a tower and sector consistent with providing coverage to Lori Vallow's apartment. And there's 2 outgoing calls, 3 incoming calls. There's 1 outgoing call to the number ending 8587, which was associated with Melanie Boudreaux. That call's a 35-minute call. And then there's 1 outgoing and 3 incomings with 0143. That number I had associated with Chad Daybell.
So since this is Arizona time At 8:53, this would be before the shooting occurred in Arizona, if that occurred at 9:13.
Yes, ma'am, correct.
Okay. So prior to the shooting in Arizona, we have an outgoing call to the number associated to Chad Daybell,
Yes, ma'am, at 8:50.
and then an outgoing call associated to a phone for Melanie Boudreaux, and then an incoming call associated to the number for Chad Daybell at 9:01.
Yes, ma'am.
And then there is a break in time before there is an additional incoming call at 9:44 and 9:45, both of those from the phone associated to Chad Daybell.
Correct. And I would just point out that that one call at 8:53, that's an outbound call to the number associated with Melanie Boudreaux, is a 35-minute call. So it could have spanned a large portion of that time window.
So when we see the incoming call at 9:01, how does that work if she's on the phone outgoing?
I need to look at the specific call detail record, but that very well could just be call waiting to where both calls occurred during that same time window. But I wouldn't be able to answer that question with the records I have in front of me.
That call is just 2 minutes, 2:09.
Yes, ma'am.
And then when we see the 9:44, we see that's just a 3-second initial call. And then at 9:45, a 7.5-minute call.
Yes, ma'am. Correct.
Slide 34. What are we seeing here?
So now we're zoomed out again because we're showing two vastly different locations of where towers that were utilized by the 5998 phone were. So we're looking at October 2nd between 1:22 p.m. and 8:13 p.m. Starting at 1:22, the 5998 phone is utilizing a tower and sector in Arizona, kind of northeast of Phoenix. And then by 7:53, the phone is utilizing a tower and sector in Utah.
When you're looking at this and you reviewed the records, the call that we see at 8:12 p.m. incoming from the phone associated to Chad Daybell, that's a 29, almost 30-minute call.
Yes, ma'am.
Is that the last call that is documented for this Walmart track phone from Idaho Falls?
There are additional calls, but I'll explain it like this. So whenever you're looking at a call detail record, if there's an incoming call and then there's duration and there's a tower and sector identified, that shows that that phone was on the network and we can show that that call connected. There's additional calls after that that don't populate those columns that would be associated with the tower. And so because of that, you could have incoming calls that would just basically go straight to voicemail because that phone is no longer on the network. So the 8:12 p.m. was the last record I saw in the call detail record where the phone was on the network to receive a call.
So slide at 35, what state are we in? What are we seeing here?
So we're back in Rexburg, Idaho, and we're looking at October 3rd, 2019 at approximately 2:15 p.m. The 9120 phone is reporting its location to Google, consistent with being in the area of the self-storage plus.
And so we see 2:15 p.m. Wi-Fi data of that a phone associated to Alex Cox at the self-storage unit.
Yes, ma'am, correct.
And then were you also provided with video to show that at 2:13 p.m. There are two individuals removing a tire and another item, a bench seat from the storage unit that was rented by Lori Vallow?
Yes, ma'am.
Slide 36. What does this show us?
So this is showing use of the 4652 phone, October the 3rd, 2019, between 2:20 and 2:22. And the phone is using a tower and sector that would provide coverage to the apartment complex for both Lori and Alex.
So on October 3rd, we now have the phone associated to Lori Vallow, receiving calls from the phone that has been associated to Chad Daybell.
Yes, ma'am.
And that phone is using a tower consistent with them being in Rexburg, Idaho.
Yes, ma'am.
Were there any other network calls that you saw for that phone from the Walmart Idaho Falls track phone?
No, not after the call that was made in Utah.
And did that end your mapping of the data provided to you by the Gilbert Police Department in relation to this case?
Yes, ma'am, it did.
State has no other questions for this witness.
All right, Cross.
Do you want me to call you Special Agent or Mr. Ballance or?
Special agent is fine.
Okay. Special Agent Ballance, I just have a couple questions. You had mentioned that if all of you, okay, so you had mentioned if all of your locations are on, which one would it track? So say you have 3 phones associated to your Gmail account and all the locations are on, what would it be tracking?
Yeah, so if you were to look at the location history where you had 3 different devices that were reporting that location, whenever you look at the record, they have a column called device tag.
Okay.
So they would differentiate that device tag. That's a number Google provides, but that device tag would be associated with each individual device. So as an example, if you were looking at, you only wanted to see the Google location for phone 1, you would need to know the device tag associated with phone 1, and you could filter out and see just where that device was. Same thing with phone 2 or phone 3, depending on how many devices are reporting location information.
So if all 3 had their location on, then all 3 would be reported, even if they were in different locations?
Yes, ma'am, that's correct.
Okay. And then what about if you have, so you're talking about a track phone being connected to a Gmail account, is that correct?
Yes, ma'am.
And then what if you have an iPad, a laptop, and a phone all connected to the same Gmail account?
So it would depend on, again, that device tag column and the device itself. So the device would need to be able to report location information. Google would need to be able to derive that location information by some method. So if you had location information turned on all those different devices, it would really just depend on the device, how it reports it, but it would show up in that same location history record.
So if you're tracking something and you say phone 1, you don't want the iPad, you don't want the laptop, you're tracking phone 1, you would be able to distinguish that out by that number of phone 1?
So I would look in the Google record, the entirety of the record, it would tell you which device tag is associated with which device. And so then I could differentiate which device was being reported and which ones weren't.
Now, where did you get your who sent you the information from Google? Did you get that directly from Google? I had missed that.
No, so those records were obtained via a search warrant. I believe it was somebody from the investigative team in Rexburg.
Okay.
But I wouldn't be able to provide you a name of who sent those records down.
And how did those records come to you? Like an email or something? Or how?
Yes, ma'am. They would usually be sent via email.
So is that like, it's a lot of data, right? So is it one giant email or several emails? How does that work?
It depends. Specific to this case, I can't remember whether it was sent via email, but we do have options to send larger files. And so if it's a Google record that has location history, has a bunch of different services that are being utilized by that user, it could be a very large file, and then it would be sent electronically to me.
through like a hard drive or a flash drive, something to that effect?
We have some ways that we can send it electronically that they're capable of transferring larger files per se.
And so the data that you received from this email or from a larger, did you receive it from an email? You don't remember if you received it from an email, is that correct?
I don't recall. I would say that given this particular file, I know it was larger, so I would guess that it probably came via some type of transferring platform versus email.
Okay. And then if you don't know who you got it from, how do you know if that information is accurate?
So I'm basically mapping out records as I receive them. So I would look at the certificate of authenticity. I would ensure that it's a record that came from Google. But aside from that, I'm mapping records as I receive them.
So you don't have any way to know if it was altered before it got to you, basically?
Correct.
Okay. And you're saying that you're getting all of your information directly from Google. So would it be different information if you had the phone itself? Or are you getting all the information from Google that you would have with this phone?
So with CAST and the specific unit that I'm assigned to, we're not looking at information that comes out of the device. We're looking at the records that were generated with particular providers. So although we could get information additionally from the forensic download of a phone, what we're looking at is those records from the providers that are maintained separate from the phone, if that answers your question.
So my question is, would you have more information if you had the phone?
Yes, absolutely.
Okay, so you could track it better per se.
I wouldn't say better. I would just say that you could potentially have more information that would help determine whether the records are consistent with the overall picture of what both the carrier records are showing and what the phone records are showing. So as an example, my phone right now, if I'm sending text messages back and forth, those messages have content, they have context of, you know, if I say I'm on the way to the airport or I'm going to leave here in 10 minutes. Separate from that, you have the records from Verizon that would show feasibly where my phone was. Now, if you marry those records up, you definitely have more information and you could tell the story better, but one's not necessarily better. It just depends on the circumstance.
So one doesn't negate the other, it just confirms it.
Sure.
Okay. So is it typical, would you say, for people to have more than one device associated to their email?
Yeah, this day and age, I would say so, just because a lot of people have more than one phone.
And you could have multiple devices, like 5 iPads and 5 phones and a couple computers, all generated and giving Google information from the same Google email?
Sure. It depends on what your, it's going to be dependent on every single individual. But yeah, if you have an iPad, a laptop, a phone, and you connect all those to your Google account, like it's not unreasonable for me to see records associated with multiple devices that have access to Google account.
Okay. And you can't put a person anywhere, right?
So anytime I'm estimating a location of a device, it's not an estimated location of a person, it's an estimated location of a device. And it really depends on the records that I obtain. So while I've been very successful in determining a location of an individual based on their device, it depends on the records of whether that search area is smaller or larger.
Okay. So if you were to give a teenager a phone with associated to your email account, and they're at an amusement park going on a bunch of rides, and then you're doing a download, it could look like you were in all these places, but you were really not. Is that true?
Can you rephrase that question a little bit?
So if you just had a track phone that was associated to your Gmail account and anyone else had it, it would look like you were in that place.
So the device, if the device is reporting to Google its location information, then I would look at those locations that it's reported as the areas where that phone was at a particular date and time.
So you can't put a person anywhere, but you are locating the device. Is that correct?
Correct. I'm locating a device.
Okay. Do you remember about what you had said that on October 3rd at 2:15, the device was at the self-storage plus. Was that the track phone?
No, that was the number ending 9120. So that was reporting its location to Google as being consistent with being at the self-storage plus.
And did the track phone ever, I want to say ping, but give a location in Rexburg after October 3rd?
Not after October 3rd, no ma'am.
Do you remember the last time when it did?
I know the last time in the call detail record was that page where it showed the phone being used in Utah, and I believe that was October the 2nd, towards the evening hours.
Do you know where in Utah that last location was?
If you were to pull up that page on the report, I could give you the area, but I know it was southeast of Salt Lake City.
Okay. There was something about the meters. So when you were talking about on page 6, you show the 3 slides with the sectors.
Okay, are you able to pull up page 6?
Oh, I'm sorry. Sure.
No, you're fine.
It's okay if I just hand it to him. Or do you want it? You can put it on. You want it on here?
Yeah.
Yeah. I don't know how to work it now.
It's okay.
You got
Oh,
Zoom.
technical.
And roll the top button. Roll. Oh, there we go.
Oh.
Roll it. The other way.
There we go.
Roll.
Sorry. I just wanted to ask a question about the meters.
Sure.
So you had said something about, is it 150 meters in each of those sectors? Was that what I heard?
So it's degrees instead of meters. So basically what you're looking at is how a sector is divided up of a tower. And so specific to this one, I think I was mentioning sector 1. And when you talk about the azimuth or direction from the tower that that particular sector is facing, you would use that azimuth in degrees to give you that direction.
So with the 2 apartments being so close in proximity, and you were talking about that it's pinging on a cell tower that shows both. So I'll show you this one. I think it's this one. 18. So this circle right here that's both apartments are within that same, is that cell phone coverage?
So that specific graphic there, when you're looking at that circle, all that circle is doing is showing the direction from the tower of where that specific sector is providing coverage to. So in this instance, that tower, that sector is facing northwest, and that particular tower and sector is providing coverage to a great deal of Rexburg. But included in that coverage would be the apartment complex for both Alex and yourself.
And so Do you know how far apart those apartments actually are?
I know they're fairly
Meters?
close. It's been a while
Oh, in
since
meters, but
since I've been out there. It's been a while, but I know there was maybe 1 to 2 buildings between, but they were relatively close.
so are you able to tell from location wise, are you able to tell the difference with a cell phone tower, or is it some other way that you're, do you see what I'm saying?
I do.
Okay.
So with this particular tower and sector, that usage at 1131, there's no way you could say definitively that that phone was at Alex's apartment, was at your apartment. You're just basically saying that's utilizing a tower and sector that provides coverage to that area. So the phone could be anywhere within that coverage area whenever that particular call was made.
Okay. But there is a way to distinguish if it was at either one, but it's not that cell phone tower.
Not via the call detail records from Verizon. You would need the Google location history, which is giving a much tighter margin of error associated with that device.
Okay, that makes sense. Thank you. So when you had spoke about the Walmart, I don't know what page that is, but you were showing that according to Google, is that correct? That a phone associated with me and a phone associated with Alex were in that Walmart shopping center? Is that
So I
correct?
think you're talking about page 16. So there's 2 different pages associated with that statement. The first one is the 9120 phone reporting its location to Google, and that's where you can see multiple locations consistent with being at that Walmart in Idaho Falls. The page following that is looking at the phone associated with you that was utilizing a tower and sector that would provide coverage to the general area of that Walmart. So it's 2 different, basically, versions of records that are providing 2 different estimates as to where those 2 phones were.
Because one is a phone call, so it has an outgoing tower. Is that correct?
So one is looking at the Verizon network, and so it's utilizing that specific tower and sector for that. I can't remember whether it was an incoming or an outgoing call. Whereas the Google location, that's information that that phone is reporting from either GPS or Wi-Fi to Google as where it's located during that same time period.
So could it connect to Walmart Wi-Fi? Does Walmart have a Wi-Fi? I didn't know.
So it wouldn't need to. If Walmart had a Wi-Fi, it doesn't necessarily need to connect to it. It just needs to see it, because when the phone takes a measurement and sees that it's has a certain signal strength from that Walmart Wi-Fi, then it is able to estimate where that phone is, because Google knows where that particular Wi-Fi hotspot is located.
Do you have the ability to track someone walking around in a Walmart?
I mean, if you looked at the Google, if you're looking historically and you wanted to see, like, did an individual go to a particular aisle in Walmart, I think that would be a stretch, unless it's a very big Walmart and you're just trying to see whether they were in landscaping or over on the grocery side. It all depends on the information that you have in that record from Google. So if those margins of error are super small, you could potentially estimate that. But it really would just depend on the record that you have specific to the device that you're trying to locate.
And if you had the actual device, could you pinpoint that more accurately?
Again, it would depend on the device and what apps you're running on the device and what all is being potentially stored. So different phones have different ways that they store information. They have different GPS chips inside of them. Apps have different ways that they store information. And so it would really just depend on getting that phone, doing a forensic download of that phone, and seeing what you have.
And then could you compare that to the Google information that you got and have a much more accurate picture?
I wouldn't say you would always have a more accurate picture, because you might not have any records that you might do a forensic download and you're not able to pull out any location information. I would say that it's always better to have more information to do that comparison, but it's not a guarantee that it's going to make it better by having the forensic download of the phone.
So it would be more accurate as far as locations from Google?
I wouldn't say it'd be more accurate. It's just, it's a different record, you know? So if you have a Google location record that has a significant number of locations, they're all 2-3 meter hits because you were potentially standing outside, that's going to be pretty precise. But it's kind of speaking in, it really just depends because you don't know what that record's going to look like until you get it and you review it.
So if you don't have your location on, are you able to track where things are, or only if it connects to a Wi-Fi?
So again, it's going to depend on the specific app that you're speaking about. So like if you go into your phone, you can turn location services on or off for a lot of different apps. And so whenever I'm evaluating records from places like Google or different applications that have stored that location data. So it really just depends on how you have your specific phone set up and what you've opted into or out of as far as location sharing.
Okay. So basically your report is indicative of phones associated to certain emails in certain locations at certain times.
So the one phone is associated with the Gmail account. That's the 9120.
Okay.
The other two phones I'm looking at Verizon records. So it's
Okay.
basically what Verizon maintained for those specific numbers.
And is one more specific than the other, the one with Gmail or the two with Verizon?
I would say that the locations being reported to Google had smaller areas to estimate where the device was. When you're talking about the Verizon records, the records that I had, I'm only able to estimate a general area based on what the coverage of a particular tower and sector provides coverage to.
Okay. And what is the radius of the tower coverage of Verizon?
So if you go back to some of my earlier statements, it's going to depend on where you're located. So downtown Phoenix, tower density follows population density. So the coverage areas in downtown Phoenix are going to be a lot smaller than if you get out into rural areas where there's just not as many users.
Mm-hmm.
And so because of that, that coverage area is going to be large. Typically, I estimate that the coverage area of a tower is going to be the area between that tower and the next tower closest to it.
So with the Verizon records, that was the one that would say 16 meters or 15 meters. Was that with the Verizon records?
No, that would have been the Google location if it's what I think you're referring to, where there's a margin of error with a circle around it. That's
Mhm.
solely from Google. That would not be from Verizon.
Okay, so with Verizon, it's more accurate, and with Google, it's with the meters, within a certain amount of meters?
It's the way that they're measuring. Google's providing their margin of error. Verizon is not. For Verizon, when we're estimating a coverage area, I'm using my training and experience of locating phones historically and estimating that phone, what the coverage area is going to be for the tower and sector that phone used.
So is it which one, the Gmail or the Verizon that is giving you the information that there was no moving of the phone from one apartment to the other?
So whenever I made that statement, it's based off the Google location history. And so what I'm looking at is for a period of time, every Google location, every line in that Google location history record. So whenever I'm looking at those and I don't see that device has either moved or gone to Alex Cox's apartment, that's all from the Google location record.
Right, so if a phone was just in a car driving around, right, then it would show it in movement everywhere that car went?
It would depend on if it's reporting its location during that movement. So let's say, for instance, that car left a parking lot of that apartment complex and drove 15 minutes north and then 15 minutes back. As long as there's a Google location record during that 30-minute window, that's where I would be able to say that there was movement. But if there's a record at 9 o'clock in the morning and then there's not another record until 9:30, I can't say definitively that that phone didn't move during that 30-minute window. All I can say is this is where it was at 9 o'clock and this is where it was at 9:30.
Because it's not reporting.
Correct. Every estimate that I make is based on there has to be a record in a line of a record for me to determine a potential location.
So can you explain that to me, what it's reporting? So if a phone is off, it's not going to be reporting anything. But if it's just sitting there stagnant, it's not going to be reporting anything? Can you
It
explain that?
depends. Typically, I've seen in records that I've reviewed on a regular basis, if a phone is stationary, it's not going to report as much. And if it's moving, it potentially would report more. But again, the phone has to be on and the phone has to be opted into location history. And that's what's going to generate that record that's maintained by Google that I can then evaluate and see potentially where a phone was in the past.
Okay, so you have access to what is being reported.
So I would have access to the Google location record.
Right. Only what the phone is reporting or what the device is reporting.
To Google, yes.
Okay. And you made your report off of what was reported, and it's not, I'm just trying to get to, it's not constant. You're not getting a phone record from, like, say, September all the way through October, and you know everything of where that went, because it wouldn't be reporting all that time. Is that accurate?
So I'll give you an analogy. Maybe this will potentially help. But if you think about, you live next door to your neighbor and your neighbor's car is in the driveway. They've got a red car in the driveway. And so at 9:02 in the morning, you go and look, the neighbor's car is in the driveway. 9:45, you go and look and the neighbor's car is in the driveway. And then one more time at say 11 o'clock, you look and the neighbor's car is in the driveway. You can only say that the neighbor's car was in the driveway at those specific instances because that's when you looked out the window. You could reason that maybe that car was there the entire time, but you can only definitively say where that car was when you have an instance that you looked out the window. So it's the same thing with the Google location record. So I can estimate where a device was as long as there's a date and time, a latitude and longitude, and a margin of error. If that's not present, then I'm not able to estimate during the window of inactivity where that device is.
So in your timeline, there could be blind spots where you don't know where the phone was or the device was or what it was doing.
If there's not a location record, I can't map it.
Okay, thank you.
Yes, ma'am.
Redirect.
So Detective, in your years working as a CAST agent, have you reviewed multiple Google records,
Yes, ma'am.
Verizon records,
Yes, ma'am.
track phone records?
Yes, ma'am.
And you told us that part of your process is to always look at the certificate of authenticity.
Yes, ma'am.
Was that done here?
Yes, ma'am.
Did anything about these records appear to be unauthentic or modified?
No, ma'am.
When you are mapping and creating these maps for us, are you just using the data and just showing us what it says?
Yes, ma'am.
In this case, you were given Alex Cox's Google or Gmail records for the homerjmaximus.com, right?
Yes, ma'am.
And that included location data.
Yes, ma'am.
And you were provided with records showing that that Gmail account was associated to the 9120 number.
Yes, ma'am. And
you were also provided, and those Google records is what gave us the GPS and the Wi-Fi location data for that cell phone 480-351-9120.
Yes, ma'am.
Then you also had the Walmart track phone, correct?
Yes, ma'am.
That phone was not reporting Wi-Fi or GPS data. You did not have any for that phone.
No, that phone was not reporting any location information to Google.
But based upon the Google records you had for the homerjmaximus@gmail.com, you were able to determine that Walmart track phone had accessed and associated with that homerjmaximus@gmail.com address.
Yes, ma'am. That phone accessed that Gmail account.
So when you're talking about the Walmart track phone, all you were able to map on that was cell tower use.
Yes, records from Verizon.
When we talk about the Walmart on September 25th of 2019, we have both the phone associated with Alex Cox, the 9120 phone that you mapped there, right?
Yes, ma'am.
And that mapping was again using the GPS and Wi-Fi.
Yes, ma'am. As reported to Google.
And that was, you were able to map that within as small as 16-meter radius.
I believe that's correct, but I'd have to look at the page to ensure the
Okay.
margin of error.
Just gonna throw this one up to make it even faster.
Yeah, so the most precise was the 16 meters.
So it's in the Walmart.
It's consistent with being in the Walmart.
So unless the Walmart's smaller than 16 meters, pretty likely it's there, especially given the number of hits that you had in that location.
I'll say that if I were looking for that device and it was, 7:15 right now, and that's the records that I was seeing, I would go inside the Walmart to look for that phone.
Okay. Now, on the other hand, you also had cell tower usage for the phone number for the phone associated to Lori Vallow, the 4652 number, correct?
Yes, ma'am.
You did not have GPS or Wi-Fi for that.
Correct. That phone was never reporting location information to Google that I had.
So for that case, you were using cell tower data.
Yes, ma'am.
And you were able to determine that that phone was using a cell tower in the area of the Walmart at the same time as this phone is showing Wi-Fi location data at the Walmart.
Yeah, I think that was at 7:08 p.m. if I remember right.
So it would be in this time frame of 7:07 to 7:16,
Yes, ma'am. Correct.
and we see over there 7:08. So basically, both of those two phones, the phone associated to Alex Cox and the phone associated to Lori Vallow, are either showing specifically Wi-Fi location data in the area of the Walmart or using a cell tower in the area of the Walmart.
Correct.
I have no other questions for this witness.
Are there any questions for this witness from any member of the jury? I don't see any, sir. You can step down.
Your Honor, at this time, the state is going to rest.
All right, the state has rested. That means the state's done with its presentation of the evidence in this case. At this time, we'll take our noon recess. Please be back in the jury room, ready to go at about 1:20 p.m., please. 1:20 p.m. Please remember the admonition.
All rise for the jury.
They're coming back for some things when the jury leaves the courtroom.
Does the defendant intend on putting on a case, any witnesses or testifying?
We plan on doing our Rule 20, Your Honor, and no.
Okay, go ahead with your Rule 20.
Can we do that when we get back from lunch?
Sure. If you're telling me you don't plan on testifying or you don't plan on calling witnesses, let's finalize the jury instructions though right now. Did you get a chance to look at those?
We did.
All right. Let me go to the state first. Why don't we do it this way? We'll just go through one page at a time to make sure everyone's on the same page. So the cover page, then page 2 is duty of the court, evidence to be considered, rulings of the court. Those are standard. Any objections to those from the state?
Here, Your Honor.
Defense.
No.
Page 3, direct and circumstantial evidence, redacted exhibits, indictment not evidence, self-represented defendant. Any objection to those from the state?
No, Your Honor.
From the defense?
No.
Oh,
No.
sorry, okay. Page 4, comments are not evidence. That was modified a little bit because the defendant represents herself. Credibility of witnesses, testimony of law enforcement officers, expert witnesses. Any objection to those from the state?
No.
Defense?
No objection.
Page 5, defendant need not produce evidence, defendant need not testify, voluntariness of defendant's statements, and then the start of the jury not to consider penalty. Again, all standard. Any objections from the state?
Judge, we actually have no statements by the defendant, so
That's true. We could probably delete that. There were, yeah, I think that's right. There were no statements, so I would intend on deleting that. Anything else from the state?
No, Your Honor.
How about from the defense?
No, we agree.
You agreed that that should be deleted?
Correct.
Okay. Page 6, presumption of innocence, burden of proof, evidence of any kind, voluntary act. Any objection to those from the state?
No.
Defense?
No objection.
Page 7, the absence of other participant, motive, and then the charged offense starts with the charged offense and then defines what is first degree premeditated murder. Any objections from the state?
No.
From the defense?
No objection.
All right, page 8, a definition of premeditation. Then we have the elements of conspiracy, scope of proof of conspiracy, and proof of membership in a conspiracy. Any objection to those from the state?
No.
Defense?
No objection.
Page 9, definitions, intentionally, knowingly. A part of the accomplice. Any objection to those from the state?
No.
Defense?
No objection.
Then on page 10, accomplice, act, and I don't know why aggravated assault in
think
there. I
that's-
must have left that in from the last one. I'm going to delete aggravated assault. I think that was on the crime prevention from our last trial. So my mistake on having that in there. I'll delete that. Other than that, any objections from the state?
No.
Defense?
No objection.
And then we have the jury foreperson and the closing instruction. Any objection to those?
No.
Defense?
No objection.
And then we have a form of verdict. Any objection to that from the state?
No.
Defense?
Oh, I'm sorry. No objection to it.
All right. Any others that I haven't included that the state has requested?
No, Your Honor.
Defense?
Your Honor, we would ask for mere presence just because they put up the videos of me being at the storage unit at that time.
Well, mere presence would apply to this crime scene itself.
I understand that,
I
but
would
I think
think.
it would cover it.
I don't think it's applicable, but I don't mind including it if the state agrees with the state's.
Given it's the conspiracy to be safe, I'm fine including
Okay,
it in there,
we'll add
Judge.
mere presence back. I think I had it last time.
Mhm.
I will probably put that. How about if I put that right behind absence of other participant before motive? In that area, it makes sense, I think.
That's fine.
All right, any other additions?
That's
All right,
it,
so
Your
when
Honor.
we come back from lunch at 1:20, the defendant will do her Rule 20 motion. When this when the jury comes back in, I'll turn to the defendant who is telling me she's going to rest her case at that time, and I'll read the instructions, go right into closing arguments. All right, thank you.
All right.
Oh, I'm sorry.
Well, I guess we're going to do a little break now. Wow. Wow. You know, wow. I just don't know what to think now. I mean, I really think that it should be a problem for her to be guilty. This Rule 20, in case some of y'all don't know what Rule 20 is, Rule 20 is she says that the state did not prove her case, and she wants it to be dismissed because they didn't prove her case, even though she don't say nothing. I'm hearing a buzzing now. Okay. I don't know what that buzzing is. I've got to figure it out, though. Because I don't have that many things. Undoubtedly, I don't know what it is. Maybe it's my phone. It's too close to me. My phone is too close to my mic, and it's causing some problems. So I'm going to try to hang on here. I'm still learning how to use this phone. Apple phone that's newer than mine that don't have no buttons on. Okay, got that put away. My internet is very slow. I mean, it doesn't seem like it's very slow, but it's really been kicking me off a lot. And so yesterday, my internet provider said, we provide the blah, blah, blah fast speed, but you have to have our brand new modem that we, like a replacement for the modem I have. And so I was like, well, send that thing and maybe this will help. Of course, the trial will be over with. But maybe I'll start using it to come on and visit with you fine people. Let's see what the chat's saying. I feel like I've been in another world. Do you hear the screechy now? Let's just do away with this for a minute because we know that Nate and them are not going to be for at least a little while, so we just get rid of them for a minute. And I'll just have to talk to you. Maybe I'll put on my thing here. Oh, no. Wait a minute, y'all. I'm still here. I have my thing here. There we go. It should be back up. There it is. So I'm just looking to see. Wow. What a mess if my internet is so babyfied that it can't even do any kind of video or even carry my video face. I like this having the comments on the screen here, but I would like it better if you could let's see, what is the word? If you could scale it and make it like take up a quarter of the page because you can't really see it. I don't think. Yeah, she thinks that she's going to get it, and I understand that. because I'm the most impatient person in the world. I would screw up a one-car funeral. I'm just saying, I am impatient. I mean, I had a car wreck one day. And it was, I was so impatient about hearing back from it. It just takes a long time to hear back from all those things. Yes, that dual sentencing here in Beach Bum. I don't know when that's going to be, but oh my goodness. I think that Kresha wants to go. Do you still hear the sound, X-Files? Do you still hear a crazy sound? I apologize if y'all had to listen to a crazy sound the whole time. I didn't hear it. If I had been, I knew that Beach Bum said that it was hurting her ears, but I didn't know that. I think that would be a real error if I have screwed that up. No, that's 90 people in here that I have. Oh, Natalie says from what she can hear, it's directly when the trial is done. I hate that. I know, just a minute. I've got my people sending me little messages. The screeching has stopped. Thank you. Yeah, I'm so and how wonderful it is that y'all have stayed in here with me, listening to a dang screech. Okay. There's something I do want to talk to y'all about today, and everyone in here knows that we don't ask for much, and for God's sakes, it's hard to ask for anything because I know everything. Everybody is in need right now. But one of our people is having a really, really hard time right now, and I know a lot of you are too. So I don't want anybody to take away anything from what they need. But one of our mods, Detective's daughter, her health has went down, and her husband has cancer, and he's lost his job. So for Detective's daughter. So I'm going to put that in the chat, and if you could share it with your friends or people that also know her, because I know she's in other chats that other people know her. So I'm going to do that right now. Hang on just a minute. This is the chat. This is the GoFundMe. And it's going to say that it's from difficult research, and it is, but I'm putting it inside YouTube. So there you can see it. Okay. And she would really appreciate it. She's been in the hospital for part of this trial. She's in the hospital, and also at the trials that happened in Idaho. She took care of our Kresha like she was her own sister and our daughter. She took care of Kresha when she needed a whole lot of loving. So I wanted to put that out there, and anybody that can help, if you could, we appreciate it. Now then, switch to something else. I am not good at at the whole changing gear stuff. But we should help people when we can. Okay, she said, did we finish the motion? Yes, we finished the motion. I think maybe there was more than one. Let me go check on that, okay? Let's see, Justin Long. Minutes entry. Okay, well, we could do this then. So what I'm going to do is I'm going to share Justin Lum's minute. It's the minutes of a hearing. Let's see if I can make this bigger. I don't think I can. Not let me see. There, I guess that's as big as it's going to get. Let's see. That ain't very big, is it? Okay, well, it says here, Superior Court of Arizona, Honorable Jennifer E. Lee, State of Arizona versus Lori Daybell, Trina A. Janine K., Pamela C. Hicks, Robert Abernathy, Inmate Legal Services, Judge Green, and Judge Wine. Minute entry complex cases. Lori and Daybell. The court is in receipt of a motion for recusal of Judge Green, Federal R Rule 4711, and a motion of an abuse of discretion hearing requested. Both received June 10th, 2023. So this is what she was doing yesterday instead of thinking of what questions she was going to ask anybody or thinking of what her closing statement or any of that. She was thinking about how she was going to try to get rid of these judges. And so she says, because the motions are alleged that the division cannot be fair, the motions will be assigned to an associate presiding criminal judge. It is ordered assigning these motions to the Honorable Kevin Wayne for resolution. Let's see what next time says. Okay. Let's make this bigger. So this is Honorable Kevin B. Wayne, the clerk of the court. State of Arizona versus Lori N. Daybell, Trina K., Pamela Hicks, Robert Abernathy, Inmate Legal Services, Judge Brinsky, Judge Green, and Judge Wine. Minute entry. Pros per defendant, Lori N. Daybell. The court has received and reviewed the defendant's motion to dismiss of the discretion and motion of the recusal of Judge Green, Federal R Rule 4711, File 9. This ruling only addresses these two motions insofar as they seek to change a judge for a cause pursuant to Arizona Rule of Criminal Procedure 10.1. To the extent that these motions seek other relief, the assigned trial judge will handle these requests. Rule 10.1 covers the change of judge cause. Rule 10.1b provides that the party may not file a motion after the hearing or trial begins. A jury was impaneled on 2022 matter of June 4th, 2025. The trial in 2021 matters has concluded. These motions, therefore, are untimely. For these reasons, defendants' request to remove Judge Green and Berinsky for cause is denied. Look at that. So there's the denial of that stuff. What about that? Yeah, she's thinking she's going to preserve her rights. She's like a staircase humor. It's what you think of after you leave the room. You know, you think of some witty thing after you've already left the room. Now, that's what she's trying to think of, witty stuff. on the back end. That's spank her and send her back to Idaho. No, I want her to have to hang out and eat some more slop. Since she don't like it. It don't seem to be very many things she, can't find joy in. So the slop, there it is. Okay, what I'm gonna do is I'm just gonna see where everybody is. I know I've been trying to keep up with it. I said they will start again. They will start again. 1:20. Here's I can figure that it's about 22 minutes from now, but then there's that 30-minute delay. I hate it because I feel like I'm letting everybody down with my stream. It's not strong and keeping people in here. Thank you, Fancy Nancy. Thank you. Detective Stoddard says she don't want her in Tater land either. Nobody does. Nobody wants her for a fact. Okay, I've got that blow up big, don't I? Let's see if I can get it smaller. See if these boys are doing anything. Yep, so it's been 47 cents. 47 cents. So, okay. So they left 50 minutes ago. And their lunch is about an hour. So they're doing, about 10, 15, 20 minutes they'll start again. So they won't have probably very much postings till then. But I tell you what I can do. I can see what let's see what he's doing.
One word, yes, from Rich. Okay.
Rich was so eloquent.
Well, we were discussing this yesterday. Is this enough to prove a conspiracy? It doesn't mean that she had to be at the scene of the crime. We have not read any text messages, heard the contents of these phone calls. But it's clear that the storage unit video has to be something that the jury is still thinking about. But it's clear that the storage unit video has to be something that the jury is still thinking about on their minds.
Yeah, I believe they have. I've thought all along that the evidence in this case with Brandon really sets forth Lori's role in the conspiracy. So my view is yes, as long as all the jurors were paying attention.
Benjamin?
I think if she had an attorney, I think this is the one case she actually had a chance to actually get maybe a hung jury. I don't know, not guilty, but at least a hung juror. She's not at the scene of the crime. You do see her, with Alex on the video and everything. However, as people listen to the jury instructions, she asked for what you call a mere presence instruction. That means just because somebody's at the scene of the crime doesn't mean that they actually did it. So I think if she had, competent counsel, I think this is the case that she actually could have maybe gotten a hung jury because she's not at the scene of the crime. Like we mentioned earlier, the cell phone evidence is kind of confusing. I think that can really confuse the jurors. And for a hung juror, all you need is one juror to be strong. And there's enough evidence here for a good defense attorney to poke a lot of holes here and say, hey, you have a lot of evidence here, but there's nothing that says that she actually conspired. Nothing on tape, no actual, video recordings or voice recordings. So I think there could be some doubt here if she had a competent defense attorney for this case.
Brandon was my client, but I agree with Ben completely. This was the weakest of the cases. Looking at it from a defense perspective, there was so many opportunities here to question. I mean, the lack of motive is probably one of the things that's really important there. But the prosecution laid out a string of circumstantial evidence, and the story holds together. I think the jury is going to have no problem understanding the story. They'll fill in the little gaps of what those conversations were in their own minds, I'm sure. But they, all the movements and the timing and everything else, the story holds together, and they weren't given anything by Lori to shake that story.
I agree with you guys, because in the last 2 days or so, what I heard, as if I put myself in the mind of a juror here, what I heard leaves so much to be explained when it comes to where is the conspiracy on Lori's behalf. And I know Trina mentioned it in her opening arguments about the religion, but obviously we never saw that. That was never presented in court.
Right.
And Justin and I yesterday, watching Hermosillo on the stand, there were times when we felt like a good defense counsel would have objected to some of the things that was said, or more so even in cross, had she taken the opportunity. We were surprised she didn't, to cross-examine Hermosillo with that very point of, where am I in this equation? Where do you see me? Do you hear from me when there's a conspiracy? And then today, when she crossed Ballance, and we have the bite where she kind of alludes to that, more so like, look, is it not uncommon for people to have multiple devices? And in your experience, she's questioning Ballance. In your experience, where does that put me? How do you know that the individual is with said device? So if they have two phones and a tablet, how do you know that person is with one of those phones or tablets? Same thing with Hermosillo yesterday when they're talking about Alex. Clearly he's a gun owner. They showed pictures of the weapons in his garage, but is it not uncommon for Americans to have weapons? Is it not uncommon for gun owners to search the web for gun-related specifics, where to shoot it? What is the bullet drop? I mean, it does seem extreme, but as Americans, we do this all the time. So there was opportunities where she could show the jury, look, yeah, they're telling you all this stuff, but this could mean a multitude of things. This doesn't mean that Alex drove to Phoenix and shot at Brandon, because at this point, they've proven that there's the Jeep that's been in Arizona at this time. This morning, they proved that the track phone was tracked in and around the area where Brandon was shot at, but they have no visual evidence of any kind showing Lori or Alex in Arizona on October 2nd. And there were moments where I feel like they missed this opportunity. And then I wonder if it resonated with the jury. So Ben, I'll ask you, is that enough on appeal? Could she throw it back at her legal counsel and say, my legal counsel failed to inform me that I could have done this or that to help my case?
Unfortunately, because she is now her own attorney and she's representing herself, she can't have anybody to blame but herself. And it's hard for the Court of Appeals to overturn anything that her advisory counsel says, because that's not how the law works here. When you represent yourself, you are the attorney and you are taking an oath to act like and know the rules of law. So there's really nothing that she can blame here. So she can probably try to file an appeal. She's trying to say that Judge Boreski didn't let in certain evidence that she wanted, or maybe let in too much evidence. You can always appeal on those grounds, but it's really tough to overturn an appeal once you have a jury verdict, unless there's some brand new evidence that we find that could have acquitted Lori that wasn't let in. So it's gonna be very hard if she's found convicted, which she probably will be, to appeal this case since she's representing herself.
That wasn't bad cross by Obi. I think the chat is going to donate for you to get enrolled in law school. I think they're supporting you right there. I mean, but there are some points there, right? Like, why have we not seen text messages about the dark spirits? I think, is that something that makes things more hazy and confusing for a jury? Rachel, what do you think?
I think if you have the right witness, it does not. but it does create an issue that the appellate court will look at. Now, in Idaho and in the places where I practice, the law is really clear in terms of its admissibility, but a very conservative prosecutor will try to avoid using evidence that can create issues on appeal if they don't think they need it. So that is clearly a choice being made in Phoenix, that they want to make sure that they keep the case really clean. I do want to throw in a reminder on why she might have not have cross-examined Ray Hermosillo. Remember, she and Chad were calling Ray a dark spirit and actually named the demon that was inside of him. So,
Yeah.
and he knows that. So, I think there's a degree to which Lori is probably intimidated by the breadth of Ray Hermosillo's knowledge about her and her background. And I think she avoided him because they've dealt with and seen him so much. I think Lori knew she couldn't touch him. But Ray could have talked about that. I think there's opportunities where some of that evidence could have come in. And so we're seeing a strategic decision to try a super conservative, clean case.
18 witnesses to none. Lori does not intend to call anyone. Mel, what do you foresee to be closing arguments for the so-called Doomsday Mom?
Yeah, my thought is that the prosecutor, Trina, looking at the history of this case, I think the Idaho cases are free. That's not going anywhere on appeal. She's going to lose. The first Arizona case with Vallow is the same. I think the strategic decision that was made in this case is that I will play it conservative. I'm not going to go with any of the 404B information. We've already got some guidance from Lori. She's probably going to represent herself. She's not going to put on evidence in her own behalf. And I think the circumstantial evidence is compelling. That storage unit and the tire and the timing and the calls, the burner phone, the location of the phone, her relationship with Melanie. There are a lot of pieces, and I've got to think the jury is wondering what in the world happened at the location where the Jeep was found. Everybody is closed-lipped. Here, Brandon speaks out. It's Lori and her brother Alex that are the people that are the subjects. I think it's going to be a clear case of a conviction. It is the weakest of the cases that's laying there, but I think the evidence is sufficient that she's going to be convicted beyond a reasonable doubt. And I think it was strategically a safe play that Trina wanted to do to take away any argument on appeal.
Yeah, we have not seen a lot about the motive, the financial part of it all. I think that is something that we were expecting to see regarding, we know the life insurance beneficiary for Brandon Boudreaux is Melanie Pulowski, but she has not been named as she's being investigated but never been charged. So I guess you can't really go there. And as Lori had alluded to, she would not benefit directly. But if you really open the door, we know exactly how she intended to benefit through the Idaho case, through this, basically pot of money that would be shared through the inner circle when the world ended. Dave, what question do we have next?
We have a great question from E.C. Meister. This is for Rich or Rachel. Do we have any real reason why Brandon Boudreaux was targeted?
Rich, do you want to run with it?
Well, it's all part of clearing the decks. This small group of people were preparing for the apocalypse and bringing the flock together under Chad and Lori. Melanie was part of the flock, and those people who they did not perceive to be part of that group of either believers for whatever reason, either they rejected it. I think Brandon rejected getting involved in it, but the rest of them got all dark spirited. Tammy, the kids, Charles, Brandon, they were all targeted, and so they all had to be gotten rid of so that the rest of them could get together and become the leaders of whatever the new world was going to be. One that was much better than when Mel was taking notes with a quill pen.
I agree with Rich. And I had to chuckle at the dark spirited, and then you stop and think about what that really means. It's the similar pattern to what happened to Charles, to Tammy. That's what was coming next for Brandon. It's getting rid of that obstacle to building that life together, to building that future for the group. And so Brandon was Mel's obstacle, and was a benefit. That group benefited financially from Mel financial contributions. And so getting rid of Brandon candidly was just the next step in their overall plan.
And it may have, also, and that's a good point, because in life insurance, Charles Vallow had switched the life insurance beneficiary to his sister, unbeknownst to Lori. So once he was dead, suddenly that pot of money was no longer available for this cause. And so they were out looking for more money, and they got a little bit out of Tammy's death, a little bit out of the kids from a Social Security standpoint and that kind of thing. But they needed that big payday. So between July and October, they needed to come up with some money.
Yeah, Chad was taking people around like David Warwick, etc., looking for property. So they needed money.
The question is, if Lori remained the life insurance beneficiary for Charles Vallow and she got $1 million, would they continue on, with the plan? I mean, I guess we'll never know, because obviously she wasn't the beneficiary. But yeah, both Brandon, Tammy, just like Charles, had sizable life insurance policies. Dave, we got one last question from the chat.
That is true. This is from Brittany Hennick. Why does the panel think the jury didn't ask very many questions?
Yeah. Good point. Not a lot of questions from jurors.
I think the jurors already know the issues here. There wasn't that much confusing. When I've done trials, when you know that the jurors we're ready to go home. I mean, basically, let's take the vote right now in the jury box. I think these jurors are ready to go home. They've heard enough, and it sounds like if they were confused about an issue, they would write a question. The fact that they're not writing questions, it means that they must believe the prosecutor, or else they would be writing questions.
There's a dynamic that we see with jurors and juries, even though they're not talking to each other necessarily. There's this groupthink that goes on, and occasionally you get a jury that thinks they're part of the investigation, and you start seeing a whole bunch of questions coming from them. Well, did you consider this theory? Did you collect that evidence? All that kind of stuff. This jury just seemed to be more like, okay, we're going to soak up what the story is. And it was a very clear presentation, so they didn't really have a lot to ask about. But I think at the end of the day, that Ben's right. They're just going to go in there and say, hey, it all hang together.
All right, final thoughts on jury deliberations. How long do you guys think that this is going to take once the jury gets the case? Anyone?
I think we'll be done by tomorrow evening. If the jury begins deliberation today, there's a chance they would return, but my belief it'll be probably tomorrow. If they return in the morning, a verdict by 1 o'clock.
Okay, 1 o'clock. Mel, what's the verdict? What do you predict?
Oh, guilty.
Just had to check.
The way.
I think what'll happen is they'll go in there. It'll take them longer to select a jury foreman than it will be to convict, but they'll probably, in some of these, I've seen what happens. They pick the jury foreman, they take a straw vote, and then they say, and that'll be late this afternoon, and then they'll say, let's go home and sleep on it, make sure everybody's comfortable with their verdict when they return tomorrow. And that way they get another day's pay out of the deal too.
Good. That's a good strategy. I mean, and then you get some dinner, pick the foreman, talk about it a little bit, go home, then tomorrow get back to work.
Yeah, I agree with the judge. I think it's going to be tomorrow afternoon, likely. They're going to want to they're going to want to do their straw poll, but they really are conscious of people paying attention and not wanting to appear quick to judgment. So there'll be some review of evidence. There'll be some conversations, but I think we'll see a guilty verdict tomorrow afternoon.
Benjamin?
I mean, I agree it'll be a guilty verdict, but I think it depends on what time they get this case and how long is Trina Kay's, closing argument and how long is Lori Vallow's closing argument. If it's a pretty short closing argument and they get the case by 3 o'clock or even 3:30, I wouldn't be surprised if we have a verdict today. But they get the case closer to the end of the day, of course they're going to go home. But this is a pretty straightforward case, and a lot depends on what time they get the verdict. But I expect either this afternoon or early tomorrow morning, they're done. I mean, they might even take the verdict right there. Judge Boudreaux might say, raise your hand, right there in there, and just count it, because I think it's been a pretty straightforward case here.
Okay, thank you to our experts. This is what we're going to do, though. Once the jury gets the case, I'm going to be in the group chat with you guys, making sure you guys going too far away, because once we're on verdict watch and we know they're not going home, we love to get you guys back on as soon as maybe this evening or tomorrow morning, as long as that jury is deliberating and not home. I think our chat and everyone watching would love to hear the insight, as we'll just, wait here for a little while together. So thank you guys again, and we'll see you soon.
Thank you.
Thank you.
All right, George, we're heading into it. The afternoon session in just a little bit. Roll 20 and then closings.
I'm still not 100% convinced the jury has been sold on this case. I think for two things. One, as we learned from the last jury, Lori's decision not to present a case weighed heavily on their decision, which again would indicate that would, if the same rule applied, then they would have enough to convict her. But to me, that can go one way or the other with this case. But also too, like you said, you need one juror, right? You need one person in that jury box to go, I understand, that there were some things, that weren't on the up and up, but I'm not sure that there was enough that the state presented, if I'm that juror, that the state presented that would implicate Lori in any of this. And the phone calls back and forth and the storage video, I could see there being at least one juror that's still kind of on the fence. But whether or not that is whether or not that's the only factor, I think the jurors can see through a lot of this. And again, outside of the fact that Lori is representing herself, this defense has not done enough. And it's almost like they've let the state once again steamroll through this trial, and I think that may be, at the end of the day, for a lot of these jurors, that could be the deciding factor. So we'll see. I think they'll take most of tomorrow. We'll see if they come back with any questions, if they come back with anything from the foreman that they want answered from either side. And then, of course, the gaps in all of this, right? The overlapping evidence where they have to be looking and going, all right, now who's Charles again? All right, they're married. I don't know really, why is he involved in this? Where Alex? Oh, Alex is dead. Oh, wow. Well, that's weird. So, there's so many unknowns from their perspective, because again, they're not supposed to know all the other nuances. I would not be shocked if they came back as a hung jury or acquitted her. But I wouldn't be shocked if they, if it was unanimous, because, again, they had enough to somehow implicate her in this conspiracy, because this is a serious charge, and I think they know that. Again, if you take anything from the first jury, if you take anything from what those three jurors told us in the days after the trial was over, it's not unheard of to think that the same jury is thinking the same thing.
All right, we're underway in the courtroom in real time. We'll see you guys in a little bit.
I have to run them off whenever they're playing the music. So I put that y'all see me. There you go. Y'all can send me. Oh my God. Let's get rid of some of that. That was too much light. No, I am so blinded. I'm gonna get my cataracts off. And all of this stuff, thank you. Well, I'm gonna have to wear glasses probably at all. I think they are backing. Let's see. I've got all these tabs open like my internet's good. Ooh, child. Let's see here. There you go. These boys are talking still. You refresh that thing. There you go. Okay, Trace says they're back in. So they're back in. So I don't know if Trace, Caitlin's with there now. She may butt in. We're going to find out momentarily. Okay, let's see. Let's see. Okay, this is what I'm going to do. I'm going to share this instead. Let's see how that's. Woo! Okay, so I'm moving up. Maybe I should do it like this. Okay. Trace says that Lori requested, that Rule 20 thing, that the charges be dropped because of lack of evidence, and Trace says the judge has denied it. So we're getting our news for Trace for a little bit. Yay! Trace is our source in the courtroom. Okay, so now I'm going to see what Justin Lumberman. Judge says, judge responds, there is enough evidence. Judge Brinsky speaking now on the case. Rule 20 denied. Jury will come in just in a bit. Daybell will have to rest officially in front of him. So that's what Justice says. And Nate says, back in the courtroom, the bailiff just told everyone in the audience that if they take any photos, they will be removed from the courtroom. He said he heard people were taking pictures this morning while the undercover FBI agent was on the stand. Now that's bad, y'all. Y'all should not do that. Nate also says the jury's back in the room now, and Lori says the defense rests. The judge asked the assistant to hand out the jury instructions. The judge tells the jury, let's get this over here. The judge tells jury they should not guess about any facts or be worried about the judge's opinion of the facts. He says they are to determine the facts. Okay. Sounds like that judge is speaking. Okay, so let's see if we can find out what Justin says. He said the jury instructions to be read now after Lori officially rests her case. I may have already read that. Let's see. Here's Joe Schmoes. Let's see what he says. Joe Schmoes says at 1:18, Lori enters, gives a little upside down smile to the advisory counsel Abernathy. At 1:19, the judge enters. 1:20, Lori begins her Rule 20 argument. It is a brief. Ms. Kay counters. There's a sufficient evidence that a reasonable jury could find this defendant guilty. The judge B agrees with Ms. Kay. Then Lori enters the Tammy Lachik letter into evidence for the appellate reason. The jury enters, the defense rests, jury instructions are handed out to the jury, and judge begins to review them. If y'all don't follow Joe Schmo on the Twitter, y'all should. He is JS_media. There is other Joe Schmoes that are not him. So it's JS_media. Okay, let's see what Justin Lum said. Okay. So he hasn't, I think y'all busy looking for a new one. Okay, here's what Nate says. 49 seconds ago, the judge says some of the exhibits have portions deleted from them for legal reasons. He tells them not to speculate or worry why they are deleted. You must not think the defendant is guilty just because of the charge, Berinsky says. Then 1 second ago, the judge says defendant's decision to represent herself should not be considered. He says in a few minutes, the prosecutor and defense will give their closing arguments. What they say is not evidence. He's telling them. Let me see what Joe Schmo has in his name. I don't understand why it's all numbered this way. Okay, Joe does. He's replying, the judge is reading directly from the instructions. All the jurors are following along. They are turning their pages at the same time. That's good to know. See, you got little reports there. If you are following true crimes, you should follow him because he's going to be following lots of crimes besides the ones that we follow. So he is really a wonderful and good source and such a kind man. That's the Joe Schmo. I'll put a link for his Twitter and the StreamYard. So later y'all can, or you can grab it and join up. Where is this thing? Here it is. Joe Schmo. That's right. I may not be spelling it, but I'll see the Twitter thing. There you go. Now. If y'all know Justin Lum. Justin, we've been following him a while, haven't we? Okay. Nate says, the defendant is not required to produce any evidence. The state must prove beyond a reasonable doubt that the defendant is not required to testify. It was her decision because she did not testify. They cannot hold that against her. Let's let that sit there for just a minute. I should have made that thing long, didn't I? I think I'm gonna edit that thing because I don't like it being so big. Still, it's long like that. Take out the trial. Y'all know we're in the trial. I'm trying to get rid of the offset on them line. I don't like that. Yeah, wasted too much time trying to make a damn banner. Sorry, algorithm. I hope that some of the precious things that didn't get monetized will be because of the curse words that I used. Lord help us. Okay, let's see if Justin Long has said anything else. No, Justin's juggling us. The judge is reading the instructions. Then we will have closing arguments. I think I read that. Heavens. Okay. Joe Schmo says that 2 minutes ago, he said, you must not consider punishment when deciding guilt. Punishment is up to the judge. Lori, you should have figured that out. But she thinks he can't do anything. So, what of it? She's like, what of it? I don't know why. Every time I put a thing in here, I lose my thing here. I don't even know what that thing is I have up here. Oh. It's like, that's part of YouTube, you silly. Too many buttons for me to push. Too many buttons. I put a thing down here. Since it's in Justin Lum's hometown, he's burning at both ends around there. Okay, so they're still having some of them. Nate says, the state doesn't have to prove motive, but motive can be considered when determining their verdict. The judge reached the charge of conspiracy to commit first degree. The defendant agreed with Alex Cox to commit first degree murder. Ooh. Child. Something, ain't it? I'm just letting that lay there a minute. We'll see what Charles says. Y'all doing okay over there? I hope y'all run everybody off. Don't really consider. I don't entirely understand how come they don't come to the top. Just not do it. I don't know what to do that. It's like I don't understand why it doesn't make the top one come to the top. It looks like these would be the only people in my feed if I'm at home. Okay. Nate says, one may become a member of a conspiracy without having the full knowledge of the conspiracy, Belinsky says. Oh, what about that? I had thought of it that way. Gee, Lori. Do I make y'all dizzy hunting through it that fast? I hadn't thought about the fact that I'm a pretty fast mover on this machine here. Okay. Nate says, the judge continues to read. Oh, I think he means read. He says reach jury instructions. I think the judge continues to read jury instructions. All the jurors appear to be following along with their own copies of instructions. Talk about our animals are giving us emotional support at this. I know this has got to be nerve-wracking for the family. Okay, I'm gonna quit making y'all sit here in a moment. So just move so fast. So Nate says the judge tells the jury to pick a foreperson. Their opinion is not more important than the other jurors. The foreperson is to make sure everyone is present during deliberation, that the discussion should be open for everyone to express their views, and all members agree unanimously on the verdict. I'm not sure if that was right either. It says all members agree unanimous on maybe it's must agree unanimously. Okay, all members must agree unanimously on the verdict. Okay. You know, I would be making a bunch of typing mistakes. So I guess let's just sit there a minute, because I'm freaking y'all out going from one page to the next, because I move pretty fast. See, I have that other Joe Schmo that that's not the right one, and because I've hunted it several times, it keeps coming back to me. Okay. Reading y'all's comments, I'm trying to be quiet for a moment. See, I should have maybe done that. So now it's going to be. Okay. If any of the jurors have any questions for the judge or want to communicate to him, they should fill out a form, and it must be communicated in writing and must be signed by the juror. The judge will consider the note and consult with the parties. He will then respond. Nate also says jurors cannot conduct any research on the case. 12 jurors must agree on the verdict. Jury instructions are done. Trina will now give her closing arguments. Yikes. Is it time? It needs to be almost time. I said, where's my thing where I wrote down what time in the central time because I'm silly. Yeah. Yeah. Sure this is. Okay, okay. So in about 6 minutes, they should come back. This ought to be very interesting, but we won't hear about closing statement. We're going to have to go through that whole thing. And I just read you what's fixing to happen. My glasses are injuring me. Let's see what she's like. Okay, I thought I'll look up Gigi at Pretty Lies and Alibi. She says, we're starting closing of the trial now. So that's the last thing there. I think that's what I showed y'all earlier. The answer. Justin Lump says Trina Kay is about to start closing and she's addressing the jury. Ooh. So I may bring that back up. I may bring up. Bring our screen back up. Sure, this is here. I just don't want to miss anything, though. Heather Rose says, show that. Heather Rose says it's 1:45 Phoenix. If closing arguments go until 3, the jury could be in deliberation by 3:15. They might even return a verdict by 4:30 or 5. If they're all in agreement going in. Oh, they dumb. What a bunch of stuff to think about one day. So let's see if Tracy's. It's going to be a time. The clothesline is her closing statement is a time. I almost said it was clothesline. Ooh. All right, let's see here what we're doing. So I'm trying to not talk too much because if I read something crazy, then I want to. I'm going to read y'all what Nate has said 2 minutes ago. Brandon heard a loud bang when the bullet struck near his head. He drove off and called 911 in a panic, Trina recalls. This defendant, co-conspirator, also drove off to try and escape, immediately calling the defendant's soon-to-be husband, Chad Daybell, and Googling a way to get back to Idaho Falls through the back roads, Trina says. Trina explains that much of the planning and premeditation occurred in Idaho. She wants to go through and present a timeline to show how it all fits together, to show you all how all of the evidence points to one conclusion, that the defendant was involved in a conspiracy to commit first-degree murder. I'm going to put that in the chat for y'all, because I might have not read it through. I'm pretty sure I did not. Yeah. Goodness gracious, it's a bit longer than what we fit into.
All right, we're back on the record. State of Arizona versus Daybell Sierra 2022-001242. The parties are present. Ms. Daybell, go ahead.
With a Rule 20, Your Honor?
Yeah.
Okay. The court must enter a judgment of acquittal on any offense charged in an indictment if there is no substantial evidence to support a conviction. Conspiracy to commit first-degree murder requires the state prove that I, one, agreed with another, in this case Alex, that one or more of us would engage in conduct that equaled first-degree murder, and two, that I intended to promote or assist in the conduct. The only evidence that has been presented simply establishes that I have been seen on video placing items into a storage unit. A phone that is connected to me through an email made phone calls during this time frame, and a Google search relating to Gilbert, Arizona. None of this evidence establishes that I agreed with Alex Cox to engage in conduct that equals first degree. The state has the burden of establishing all elements of an offense have been committed, and thus there is not substantial evidence to support a conviction.
All right. Does the state want to respond for the record?
Sure. Looking at the evidence in the light most favorable to the state, there is substantial evidence for a jury to find the defendant guilty of conspiring with Alex Cox to commit first-degree murder of Brandon Boudreaux. In this case, in determining if a conspiracy existed, the jury can look at the fact that the defendant went with Alex Cox to buy the burner phone, that she loaned her Jeep to him to be used, that she rented a storage unit, that she Googled how to remove the rear seat, that she hid the tire and seat, and that she created an alibi for her brother by having those two phones interact while he was in Gilbert, Arizona.
All right. The standard is whether a reasonable juror could find the defendant guilty, whether there's substantial evidence that a reasonable juror could find the defendant guilty. The state has presented a compelling case that Alex Cox traveled to Gilbert, Arizona and attempted to kill Mr. Boudreaux. There's other circumstantial evidence that establishes that the defendant was aware of Mr. Cox's plans and facilitated those plans and assisted in those plans in several different ways. It's ordered denying the motion for Rule 20. Anything else? All right, just confirming that the defendant doesn't intend on testifying or calling any witnesses.
Correct. I would like to again just admit the letter from Tammy. It was marked.
Did we
Just
get it
wanted to
marked?
let you know that.
Okay, 203, for purposes of maintaining the record and any appeal issues, 203 would be admitted for the record, but not to the jury. Anything else? All right, let's bring the jurors in. I'll turn to the defendant when the jury's sat, and the defendant presumably will say that she rests as well. Thank you.
All right, the jury.
Be seated when you get to your seat. All right, thank you. The jury is now present. Everyone can be seated. The defense has rested before lunch. I'll now turn to the state rested before lunch. I'll now turn to the defense.
The defense also rests, Your Honor.
All right, at this time, we are going to hand out the final jury instructions. My assistant will hand those to the jurors. Do the parties already have their copies?
Yes.
Okay. All right, it looks like all jurors have copies of the final jury instructions. Much like the preliminary instructions, you're free to follow along or just listen. I'm going to read these instructions as required. It is your duty as a juror to decide this case by applying these jury instructions to the facts as you determine them. You must follow these jury instructions. They are the rules you should use to decide this case. It is your duty to determine what the facts are in the case by determining what actually happened. Determine the facts only from the evidence produced in court. When I say evidence, I mean the testimony of witnesses and the exhibits introduced in court. You should not guess about any fact. You must not be influenced by sympathy or prejudice. You must not be concerned with any opinion that you feel I have about the facts. You as jurors are the sole judges of what happened. You must consider all these instructions. Do not pick out one instruction or part of one and ignore the others. As you determine the facts, however, you may find that some instructions no longer apply. You must then consider the instructions that do apply together with the facts as you have determined them. You are to determine what the facts in the case are from the evidence produced in court. If the court sustained an objection to a lawyer's questions, any answer given. Any testimony stricken from the court record must not be the question what the answer to the question might have been. If an exhibit was offered evidence and it was considered as evidence. If testimony was ordered stricken from the record, you must not consider that testimony for any purpose. If evidence was admitted for a limited purpose, you shall consider that evidence only for that limited purpose. Do not concern yourselves with the reasons for my rulings on the admission of evidence. Do not regard those as indication from me of the credibility or weight you should give to any evidence. Evidence may be direct or circumstantial. Direct evidence is the testimony of a witness who heard or otherwise sensed an event. Circumstantial fact. There is no distinction between just direct and importance to be given to the evidence regardless of whether it is direct or circumstantial. Some of the exhibits that have been admitted into evidence have had portions deleted from them for legal reasons. Do not concern yourselves with the reasons why some portions of the exhibits have been might beyond a reasonable doubt. The defendant in this case represents herself. All instructions I read to you that include references to lawyers or attorneys apply equally to the defendant's self-representation at trial. In their opening statements, the prosecutor and the defendant talk to you about the law and the evidence. In a few minutes, the prosecutor and the defendant will give their closing arguments and will talk about the law and the evidence. What they said or say is not evidence because it is not sworn testimony, but it may help you to understand the law and the evidence. In deciding the facts of this case, you should consider what testimony to accept and what to reject. You may accept everything a witness says, or part of it, or none of it. In evaluating testimony, you should use the tests for truthfulness that people use in determining matters of importance in everyday life, including such factors as the witness's ability to see or hear or know the things the witness testified to, the quality of the witness's memory, the witness's manner while testifying, whether the witness had any motive, bias, or prejudice, whether the witness was contradicted by anything the witness said or wrote before trial or by other evidence, and the reasonableness of the witness's testimony when considered in the light of the other evidence. Consider all of the evidence in the light of reason, common sense, and experience. The testimony of a consider the testimony just as you would the testimony of other witness. A qualified as an expert by education or experience state opinions on matters that witnesses and may also state reasons for those opinions. Expert opinion testimony should be judged just as any other testimony. You are not bound by it. You may accept it or reject it in whole or in part, and you should give it as much credibility and weight as you think it deserves, considering the witness's qualifications and experience, the reasons given for the opinions, and all the other evidence in the case. The state must prove guilt beyond a reasonable doubt based on the evidence. The defendant is not required to produce evidence of any kind. The defendant's decision not to produce any evidence is not evidence of guilt. The state must prove guilt beyond a reasonable doubt based on the evidence. You must not conclude that the defendant is likely to be guilty because the defendant did not testify. The defendant is not required to testify. The decision on whether or not to testify is left to the defendant. You must not let this choice affect your deliberations in any way. You must decide whether a defendant is guilty or not guilty by determining what the facts in the case are and applying these jury instructions. You must not consider the possible punishment when deciding on guilt. Punishment is left to the judge. The law does not require a defendant to prove innocence. Every defendant is presumed by law to be innocent. You must start with the presumption that the defendant is innocent. The state has the burden of proving the defendant guilty beyond a reasonable doubt. This means the state must prove each element of the charge beyond a reasonable doubt. In civil cases, it is only necessary to prove that a fact is more likely true than not, or that its truth is highly probable. In criminal cases such as this, the state's proof must be more powerful than that. It must be beyond a reasonable doubt. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every doubt. If, based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, crime, you must find that the state has proved beyond a reasonable doubt that the defendant committed a voluntary act. A voluntary act means a bodily movement performed consciously and as a result of effort and determination. You must consider all the evidence in deciding whether the defendant committed the act voluntarily. The only matter for you to determine is whether the state has proved the defendant guilty beyond a reasonable doubt. The defendant's guilt or innocence is not affected by the fact that another person or persons might have participated or cooperated in the crime and is not on trial now. You should not guess about the reason any other person is absent from the courtroom. Guilt cannot be established by the defendant's mere presence at a crime scene, mere association with another person at a crime scene, or mere knowledge that a crime is being committed. The fact that the defendant may have been present or knew that a crime was being committed does not in and of itself make the defendant guilty of the crime charged. One who is merely present is a passive observer who lacked criminal intent and did not participate in the crime. The state need not prove motive, but you may consider motive or lack of motive in reaching your verdict. I will now tell you about the crime with which the defendant is charged. Count 1, conspiracy to commit first-degree murder. The crime of conspiracy to commit first-degree murder requires proof that the defendant, on or about October 2nd, 2019, with the intent to promote or aid in the commission of first-degree murder, agreed with Alexander Cox that at least one of them or another would engage in conduct constituting the offense of first-degree murder. The crime of first-degree premeditated murder requires proof that a person, 1, caused the death of another person, and 2, intended or knew that he or she would cause the death of another person, and 3, acted with premeditation. Premeditation means that the defendant intended to kill another human being or knew she or a co-conspirator would kill another human being, and that after forming that intent or knowledge, reflected on the decision before killing. It is this reflection, regardless of the length of time in which it occurs, that distinguishes first-degree murder from second-degree murder. An act is not done with premeditation if it is the instant effect of a sudden requires proof one defendant agreed with another, with one or more persons, that one of them or another person would engage in certain conduct, and 2, the defendant intended to agrees to aid or attempts to aid another person in planning or committing the offense, or 3, provides means or opportunity to another person to commit the offense. Act means bodily movement. The case will soon be submitted to you for your decision. When you please remember that the person's opinion is not the jury foreperson's responsibilities include the following. Make sure every member of the jury is present during the discussions and deliberations. 2, make sure that the deliberations are conducted respectfully and that all issues are fully discussed. The discussions should be open and free so that every juror may participate. 3, all jurors should be allowed to state their views about the case and what they think the verdict should be and why. 4, all members must agree unanimously on any verdict. Therefore, the foreperson should count the votes to ensure that every juror has voted. 5, if you reach a verdict, fill out the verdict form and then sign the form on behalf of the jury. 6, if the jury reaches a verdict, the foreperson will inform the courtroom assistant. When the jury returns to the courtroom, the foreperson will bring the signed or unsigned verdict form as well as any question forms that may have been used. 7, when you return to the courtroom, the court will ask the foreperson whether the jury has reached any verdict. The foreperson will respond yes or no. The foreperson is not expected to read any verdict to the court. That will be done by the clerk. In just a few minutes, you will hear the closing arguments in this case. After that, the case will be submitted to you for decision. I suggest that you discuss and then set your deliberation schedule. You are in charge of your schedule and may set and vary it by agreement and the approval of the court. After you have decided on a schedule, please advise the courtroom assistant. You are to discuss the case and deliberate only when all jurors are together in the jury room. You are not to discuss the case with each other or anyone else during breaks or recesses. The admonition I have given you during the trial remains in effect when all of you are not in the jury room deliberating. After setting your schedule, I suggest that you next review the written jury instructions and verdict form. It may be helpful for you to discuss the instructions and verdict form to make sure that you understand them. Again, during your deliberations, you must follow the instructions and refer to them to answer any questions about applicable law, procedure, and definitions. Should any of you or the jury as a whole have any question for me during your deliberations or wish to communicate with me on any other matter, please utilize the jury question form that we will provide you. Your question or message must be communicated to me in writing and must be signed by you or the foreperson. I will consider your question or note and consult with the parties before answering it in writing. I will answer it as quickly as possible. Remember that you are not to tell anyone, including me, how you stand numerically or otherwise until after you have reached a verdict or have been discharged. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case. You may not use any electronic device or social media to communicate to anyone any information about this case or to conduct any research about the case until I accept your verdict. 12 of you must agree on a verdict. You must be unanimous. Once all 12 agree on a verdict, only the foreperson needs sign the verdict form on the line marked jury foreperson. You will be given one form of verdict. The verdict form reads as follows. There is no significance to the order in which the options of guilty and not guilty are listed on the verdict form. At the back, this is the sample verdict form. You'll get an official verdict form from the clerk. But this is the sample verdict. Count 1, conspiracy to commit first-degree murder. We, the jury, duly impaneled and sworn in the above entitled action, upon our oaths, do find the defendant, Lori Daybell, as to the crime of conspiracy to commit first-degree murder occurring on or about October 2nd, 2019 as follows. Check only one, and the options are not guilty or guilty. The state can proceed with its closing argument. Treya, the mic up there. We're going to put a mic up on the podium.
would want to kill you? That is a question that Officer Mary Ann Robb asked Brandon when she first arrived. That's a question that Detective Pillar asked Brandon when he spoke with him. Brandon Boudreaux gave the exact same answer to both of these officers. He gave them two names. Lori Vallow, the woman seated over here, and Alexander Cox. He told them that he believed his shooting had something to do with an incident that occurred in Chandler in July of 2019, a couple months before this. He pointed them to that. He told them that Lori Vallow had lived in Texas and that the Jeep used in this shooting was from Texas. And then he told them what happened. Come home. There were
Hey, y'all. If there's anybody here, hang on. I don't know what's the matter with my crazy internet today. It should not be doing all this nonsense. But here it has been.
The burner phone. We heard this morning from Nick Ballance, and he talked to you about both the records that you have seen that were admitted, as well as now the Google location data and cell phone analysis. What do we know? That on September 25th, when that burner phone was purchased at that Walmart, Alex Cox's phone is there, and Lori Vallow's phone is using a cell tower in that area. They drive out of town to a different Walmart to go buy this phone. Lori Vallow doesn't live in Idaho Falls. She lives in Rexburg, but her phone is in Idaho Falls talking with Melanie Boudreaux. What do we know the next day? Alex Cox activates that burner phone. That burner phone is only going to be used for one trip. The trip to Gilbert, Arizona and back. This is what you learned from Nick Ballance this morning. That again, Alex Cox's phone tied to that Google account is showing right there in the Walmart. This defendant's phone is also in Idaho Falls, utilizing a tower at that Walmart. Then we know on the 26th, when we're activating this phone, Melanie Boudreaux flies up here to be with the defendant. We know at this time, Brandon Boudreaux has the kids, and we know that they have an agreement. Brandon will keep them Monday and Tuesday and Wednesday. Wednesday, October 2nd, he will hand them back to her, and they will stay with her. So when he's shot and killed, it won't matter because she'll have the kids. It'll be fine. They know, because it's the plan, that their youngest gets dropped off every morning. Brandon will pull up to the park and let her know he's there. And so all of this information is known. Now, how do we know it's known? We know by the timing. And so we'll go through that. But remember, this is when Melanie's coming up and spending 3 days with this defendant. She has to be back Monday. Why? Because she's going to take the kids like she always does. Again, we have Alex Cox preparing for this shooting. We know he's not only practicing, but he's trying to figure out trajectory. What do we know? That this is a moving car. Alex Cox is going to have to try to fire out the back of a Jeep at a moving car. And ladies and gentlemen, he came pretty close to being successful at that. We know that Melanie flies back to Arizona. And then we have the beginning of the trip. And the beginning of this defendant starting the giant alibi defense that she does. Why would anyone ever take someone's cell phone and carry it around with them? Why would you take someone's cell phone and do that? Why would you make phone calls between each other other than to ensure that it looks like Alex Cox is still in Idaho? They think he has a burner phone. No one will even know. Great idea, other than we know he hooked it up to his Google account. So we know that the afternoon of the 30th, Alex takes his phone over to his sister's apartment. And it stays there or with this defendant until he returns on the 3rd. We know that at about 5:15, Lori Vallow searches how to remove the back seat of the Jeep. Alex Cox still is there. And now she is helping him get ready for his trip. She has his phone. She's giving him her Jeep, and she is helping him make it more comfortable so he can lie in wait in the back. They had to remove the tire, and they had to remove that back seat. We know that sometime that evening, Alex Cox leaves Idaho and moves towards Gilbert. We heard from Detective Pillar that there was an LPR reading for that Texas license plate LWD 0997 at around 8:10 outside of Rexburg, Idaho. We know from the Ballance that there is no phone activity until we see the phone arrive in Arizona. We also know that the Jeep is in Arizona. So we have the burner phone and the Jeep, and Alex Cox is Googling in Arizona. Holbrook, we see that LPR reader showing the Jeep with no tire on the back, so they can open that rear window exactly as Brandon explained. This defendant's Jeep. What do we know is that, again, the burner phone is calling one person, this defendant's husband, Chad Daybell. We see that Alex Cox is in Arizona with other physical evidence. What is that? It's that receipt from Los Favoritos that was recovered inside the Jeep in Idaho. So we know the Jeep is down here. As much as the defendant wants to tell you about colors or whatever else, her Jeep was here in Mesa on October 1st of 2019. We can just stop pretending that didn't happen. We know as well, when we look at those Google records, we're trying to authenticate them, that the Los Favoritos was on Power Road in Mesa. And after having lunch, Alex Cox Googled another location on Power Road. Now, this defendant, in aiding this conspiracy and helping her brother, starts by renting that storage unit. Now, she rents that on October 1st. She also still is in possession of her brother's phone. So this way it looks like Alex Cox is going with her to the storage unit. She's providing that alibi because they don't think that the burner phone has hooked into this Google account. They don't know about the LPR readers. They don't think about the receipt. So Lori Vallow provides his alibi and she brings the phone with her, and we know that Alex Cox's phone is with this defendant as she's renting a storage unit. Even though we know from the video, he's not there. She's alone. When you watch these videos, and if you want to, they're obviously admitted, you will see one person get in and out of that car, and one person go into the storage unit. That one person is this defendant, Lori Vallow. So even though Alex Cox's phone is here, that's just a ruse. That's her aiding, that's her conspiring, that's her trying to cover up this murder, or her brother, who is the shooter. What we know as well is by October 1st, we know the Jeep and Alex Cox are here in Arizona. And we know that that evening of October 1st, he Googles that address. The address that only 5 people knew. The address that this defendant's niece, the person she said she's like a mom for, That's where her ex-husband or soon-to-be ex-husband is living. He Googles 3875 East Phelps Street, even with the zip code into it. And then he gets directions there, getting prepared, knowing where he needs to go the next morning. Why? Because again, Melanie and Brandon have a very set schedule, and they know that Brandon's going to drop off the kids and then meet Melanie to pass off their youngest, and Alex will be waiting at home. We know the next morning, Alex Cox Googles again the address for Brandon's home. We know that that morning, Alex Cox's burner phone is utilizing towers near this defendant's niece, Brandon Boudreaux's soon-to-be ex-wife's home, Melanie Boudreaux. And we know that the calls that he is having are with this defendant's husband, Chad Daybell. And we know that by 7:22, Alex is moving towards Brandon's home. He knows that Brandon is going to be leaving to take the kids to school because Melanie knows the schedule, and he will be waiting when the kids are dropped off. The morning of October 2nd, Brandon has a very normal schedule. He's got to get his kids to school. He leaves around 7:25. He drops off his first kids at school, and then he meets with Melanie and drops off their youngest. Melanie does not know that Brandon is going to work out. Normally, he'd go home. Alex would be waiting there. But instead, he went to the gym. Now, again, we've heard a lot of questioning of whether or not a Jeep existed there or not, but we all know that it's this defendant's Jeep. But we also know that a neighbor across the street saw the Jeep there, and not only saw it, but knew something was wrong. He told you that it was parked on the wrong side of the road, nose to nose with that white van, that it was running, that it had really dark tint. And in fact, he told you he was so thinking it was out of place that he actually looked in his rearview mirror to try to just see what the license plate was, and he noted it was a Texas license plate. He told you it was just a dark Jeep, whatever color that is. And we know at this time period, again, this defendant's co-conspirator's burner phone is still calling one person, and that is Chad Daybell, this defendant's husband. Now, we know that this defendant has been carrying around Alex Cox's phone, the phone subscribed to him, the one that if you looked at, you'd be like, oh, there's where Alex Cox is. Look at that Wi-Fi. She's been carrying it around, and now she knows if at 7:40 there's going to be a handoff of the kids, you need to make the alibi, 8 o'clock. And so at 8:02 Arizona time, she has Alex Cox's phone call her phone, and there's a fake 24-minute call. Look, Alex couldn't have done that. He's up here in Idaho with me. Of course, Brandon was at the gym. So it's a little early, but still, it's an alibi. Can't have run down to Arizona in those next 40 or so minutes. So we know, of course, that while that fake call is going on, the Idaho Falls burner phone is in Gilbert, utilizing cell towers that are in the area of 3875 East Phelps, and Lori Vallow's Jeep is parked right outside of Brandon's house, waiting for him to return home. We know that 20 minutes before Alex Cox shoots at Brandon, Lori Vallow's phone gets a call from Melanie Boudreaux. Here they are, still talking and conspiring, trying to figure out what's going on. Where is Brandon? Brandon returns home about 9:13. Alex Cox has been waiting there now for almost 2 hours. He returns home and sees that Jeep. Just like Robert Abitamarco, he notices it being parked really close to his driveway and it stands out to him. And of course, then he sees that window open and that barrel come out and this gun shoot at him and almost hit him. We know from Lynette Mendoza, who had a Ring camera, that just a few seconds before that shooting, her Ring camera had shown a black car. And you just see a bleep of it in the beginning as it kind of jumps, go by that corner. And then a few seconds later, you hear that loud bang. When you look at the time on that Ring camera that you have admitted, it matches up with that 911 call with when Brandon is calling in to say he's just been shot at. Like Brandon said, loud. You've heard a lot about the color of this Jeep. Even when we look at photos of the exact same Jeep here, they all look a little different. You have the DEA one that looks almost silver, brown, I don't know. You have an upper one from Chandler that looks a different gray with a dark gray, and then you have the one from Dan Moss that looks more greeny colored. What do we all know? They all have the same license plate on them. They're all this defendant's Jeep. So when we're talking about color, that's just everyone's perspective. What do we know in actuality? That Brandon's Tesla was shot by a large round, that it hit the corner of that glass that went up into the frame of his vehicle, that it left a divot in the glass, and that somehow the police, in trying to search a giant block radius, were not able to recover those pieces of the projectile. We only have a few fragments of it. But everyone who has worked these scenes knows that's a bullet hole, and those were projectile fragments. And that was a gun that Brandon saw, and that's a shot that he heard. Immediately after hitting Brandon, Alex Cox takes off and is searching for directions out of there. You saw those, and you saw a map as he went east, and those matched with the cell phone and cell tower records that Nick Ballance told you about. Brandon is on the phone with 911. Alex Cox is fleeing because he knows Brandon's alive. We know that the other part is that while this is going on, while Alex is searching for his way home and has been talking to Chad Daybell, knowing now that Brandon's alive, what do? They go hide the tire and hide the seat. So the timing of those videos when Chad Daybell, person who is talking to Alex Cox, and this defendant go to the storage unit is as Alex Cox is calling him and telling him whatever as he's fleeing to go home. So we know that they arrive there, and you can watch these. By they, I mean Chad Daybell and Lori Vallow. And we know that they bring in a tire and what looks like a seat. You can actually see Chad rolling the tire in. And again, why is this important? This is this defendant who has helped take the tire and seat out of her Jeep to make it available for her brother to take his guns down to Arizona to shoot at her niece's soon-to-be ex-husband. That's what we're talking about when we're talking about this conspiracy. As time goes on after the shooting, we know that, again, that burner phone and that Jeep are returning back to Idaho. In fact, Alex Googles all the way to Idaho Falls Airport. He knows how to get home from there. While he's doing that, again, we're having the storage unit. Let me do this. What do we know as the Jeep is coming back? It's back in Idaho and around Rexburg around the time of 3:54 and 4:28 when LPR readers note the Jeep back up there. What do both this defendant and Alex Cox do? They're both searching, trying to get the news. Brandon shot? Did he die? Did he live? What happened? Do they have leads? And again, when we talk about the Jeep and this idea that somehow it's not this defendant's Jeep, that she wasn't involved in this, we know that there was gunshot residue, characteristic particles that are unique to just gunshot residue located in the back of this Jeep, not on the seat or the floor, but on the windows. Why? Because when a gun is shot inside of a car, that dust goes everywhere. And that's why they were able to collect that. But do we know that even though this is the defendant's Jeep, Alex Cox's DNA is on it? So let's talk about the jury instructions. I want to go through a few of them in specifics and then talk to you about the charges. Burden of proof. The state has the burden of proof, as we should, and we always will. You're told that the burden of proof is proof beyond a reasonable doubt. And you're told that proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. That there are very few things in this world that we know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every doubt. If, based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find her guilty. When we talk about reasonable doubt and that burden of proof, I want to start with what it isn't. Proof beyond a reasonable doubt is not proof beyond all doubt. It's not proof beyond all possible doubt. It's proof beyond any reasonable doubt. And I'll give an example. When Kyle Mueller was on the stand and he was questioned about gunshot residue, he was asked, for instance, if a bunch of hairspray could cause the GSR in the car. And he said, well, maybe like one of the particles, but not all three. So maybe if all they had found, possibly you could say that was a doubt, but is it a reasonable doubt that hairspray caused the GSR in the car? No. So let's talk about direct and circumstantial evidence. And that's because we have a mixture of both here. So direct evidence is evidence that a witness saw, heard, or otherwise sensed an event. What Brandon told you about that happened that day. What Robert Abotamarku told you about. That's direct evidence. Circumstantial evidence is the proof of a fact or facts from which you may find another fact. And you're told the law makes no difference between direct and circumstantial evidence. So I'm going to give you an example here as well so that we can understand what you can do with circumstantial evidence and why it is so important. Assume you are seated on a beach and it's in a cove and you can see on each side, you lose sight of people. While you're sitting there, you're the only person on the beach. There's no footsteps there, and you see a person come from your left, walk in front of you, and go to your right. They go around a corner, you lose sight of them. A couple minutes later, someone comes in and says, hey, did you see anyone come by? And you say, yeah, they just went that way. That is direct evidence. You saw it. Now imagine you're on that same beach, same situation. Sand is smooth. You close your eyes for 5 minutes. When you open them, you see footsteps now on the beach. You can see the toes and the heel. So you can see the direction as it crossed again from your left to your right, but you don't see a person at all there. You know, your eyes have been closed for about 5 minutes. Someone comes up and says, hey, has anyone gone by? And you go, yeah, I mean, in the last 5 minutes, someone went that way. That is called circumstantial evidence, and you are able to infer from that that someone went by. So let's talk about the crime. The conspiracy to commit first-degree murder requires that the defendant on or about October 2nd, 2019, with the intent to promote or aid in the commission of first-degree murder, agreed with Alexander Cox that at least one of them or another would engage in conduct that constituted first-degree murder. I'm going to go through a few things, then I'm going to talk about them all together, because these jury instructions really have to be considered as one. So conspiracy. When we're talking about conspiracy, we're talking about the defendant agreeing with Alex Cox and others to engage in that conduct, first-degree murder. That she had to intend to promote or assist, and that's going to be very important here, in the commission of that conduct. She doesn't have to be the shooter. She has to promote or assist it. And that the intended conduct would constitute the crime of first-degree murder. Again, doesn't have to be completed. That's why it's conspiracy to commit first-degree murder. Proof of the membership. You're told that one may become a member of a conspiracy without knowing every detail. She doesn't have to know how long Alex is waiting there, what type of bullets he's going to use. The evidence must show beyond a reasonable doubt that the conspiracy was knowingly formed and that the defendant or other persons participated in the unlawful plan with the intent to promote or assist the carrying out of the conspiracy. In determining whether a conspiracy exists, you should consider the actions and statements of all of the alleged participants. So you're going to have to look at everything and look at what this defendant did to promote or assist that conspiracy. So, first-degree murder. Again, I'm going to just note that conspiracy means the parties agreed to engage in that conduct, so it doesn't mean there has to be a death. They are conspiring to kill someone. So, we know that someone shot at Brandon Boudreaux and came very close to causing his death. They have to intend or knew that he or she would cause the death of another person, which when you are shooting at them with a rifle, that is what you are intending or knowing. And they acted with premeditation. Talk about premeditation and then we'll wrap it all together to discuss. So premeditation means that they intended to kill another person and that they formed an intent or knowledge and then reflected on it. Now, in Arizona, premeditation does not require some long, drawn-out plan. Reflection can be very fast. But in this case, we have premeditation that is days and weeks before this. We're talking about September 23rd, 24th, 25th, all the way through up to October 2nd. So this premeditation is above and beyond what is required by the law. This defendant started helping when they went to buy that burner phone, when she loaned her Jeep to allow it to be tinted, when she Googled how to remove that rear seat, and they took off the tire, and she kept it with her. Then she rented a storage unit and put it in there. When she kept her brother's cell phone and kept it with her as she went around Idaho, and when she made that call between those two phones, right around the time of when the shooting was supposed to occur. That is the aiding and the promoting done by this defendant. That is her acts. That is the conspiracy. But again, you look at all of the evidence to see how does that fit in. It's not just someone holding someone's phone. If that were it, sure, you might wonder what's going on. But you can't look at these facts simple and separate. You have to look at the actions of everyone and see how that fits in with all the evidence in this case. This defendant didn't just go buy a phone at Walmart and that was that. This defendant didn't just rent a storage unit and put her own personal property in there. This defendant didn't just decide to loan her Jeep to her brother and then decide to take the rear tire off it and the interior seat out of it. She did all of these things to aid and promote this first-degree murder. When we're talking about defenses in this case, there are potential ones we'll talk about. You've heard in this trial that maybe there was no shooting. It's not even a first-degree murder because I believe there were some thoughts about that the hole in his car was made by a tire iron or whatever other defenses there were. But what do we know? Yes, there's a shooting here. Brandon's car has a bullet hole in it. There are fragments from that bullet hole in there. There's damage to his glass consistent with that location of the bullet hole in his car. Brandon called 911 out of breath from the fear of having just been shot when that bullet hit the frame of his car right near his head and shattered that window next to him. The Ring camera and that gunshot that you heard. Robert Abitamarco putting the Jeep there is idling there. So, is that a defense? No. There was a shooting. So what else? We've heard something about Melanie doing it. She had a financial motive. And I'm not here to tell you that Melanie wasn't involved in this. I'm telling you that this defendant was also involved in this. When we talk about a conspiracy to commit murder, there can be multiple people involved in that conspiracy. There were multiple people involved in that conspiracy. Melanie Boudreaux is the only one that had the address. So yes, she was involved. But was she it? No. This defendant helped ensure that her brother could help Melanie by killing off her soon-to-be ex-husband, by loaning him the Jeep, by helping make the Jeep available and accessible to fire out of, removing that rear tire, removing the seat, allowing him to put the dark tint on it, and taking it with him. And then providing that alibi over those days while he was gone to help cover up that he was the shooter. I think she also said maybe she's not responsible for what her brother has done. But we know she is responsible. She is a co-conspirator. She is assisting, she is promoting in this crime. We know from the 25th on, she is helping to get the phone, to get ready, to make the Jeep ready, to cover up for her brother, to hide those extra parts, to Google how to even get the Jeep ready, and eventually also trying to figure out what went wrong so they could then determine what to do after. Brandon Boudreaux knew who was involved. He may not have seen who did this. The defendant has tried to explain away the evidence and questioning witnesses, asking if it's possible for a single piece of evidence
to mean something other than what everyone knows it means? Is it possible that a Coke bottle broke in the street and one little shard stayed there right where Brandon Boudreaux's Tesla was located when it was shot? A shard that looks just like the glass from his car in the driveway inside the seats. Is it possible that a tire iron made that bullet hole in the Tesla? Is it possible that the GSR in the Jeep is hairspray and fireworks? Is it possible that a Jeep with Texas plates belonged to someone else who wanted to kill Brandon? Is it possible that Alex was in Idaho and called her on October 2nd at 8:02 for those 24 minutes? Don't fall for the defendant's questions about what is possible when the evidence shows exactly what occurred. The only explanation when we look at all of the evidence together is that this defendant conspired with her brother and others to try to kill Brandon Boudreaux. The state asks you to look at all of the evidence, not just the is it possibles, and find the defendant guilty of conspiracy to commit first-degree murder. Thank you.
All right, the defense can give its closing argument.
When a family breaks apart, it is a tragedy, with the devastation far-reaching, affecting many people. I am not exempt from tragedy, none of us are. But what we learn from it is most important. Because of this experience, I've studied the law and the judicial system, and that knowledge will stay with me forever. When we experience tragedy, we can grow stronger from the experiences, and then those experiences are not all negative. You would think that often people in my position would feel defensive or angry. And from where I'm standing, I understand that very well. But I don't feel any of those things. You have watched me under pressure, under scrutiny, and even under attack. And I have shown you that I'm not on any of those things.
I'm going to object to character evidence and testimony that's not in evidence.
Ms. Daybell, can I have you pull that microphone a little closer, please?
You can't be upset with people who are forced to look at your life from a distance or judge it through a lens that's being intentionally distorted or being at least very limited. Like the lens the state has shown you on this event. There's so much more going on that is not included to your view. The law prevents some of these things from being shared in trial.
Object, Your Honor, to improper.
Sustained.
You have seen opinions formed by strangers trying to put together a narrative. I have shown you that basically there is no defense to what a person did not do or did not participate in. Other than what you've seen, which is no evidence that I made an agreement to commit a crime, because no such evidence exists. So I'm not defensive. I'm not angry. Nobody has all the pieces to this puzzle. It is complex. Like most families, this is a complex issue. And like the state, I was not there. But there is no agreement, no plan, no game. I am no stranger to tragedy. The breaking up of a family is tragedy. On June 25th, 2019, Brandon Boudreaux decided that I was responsible for his family tragedy. And I'm really sorry that he feels that way.
No, Your Honor, I'm going to object again to testimony.
All right, the jury is reminded that what is said in closing statements or closing arguments is not evidence. It is not testimony. The intent of the closing argument is for each side to argue what the evidence shows. Go ahead.
I did and have supported my niece Melanie when she suffered tragedy as a young child and during this terribly difficult time in 2019. We read the text from Brandon to me on June 25th, 2019, where he claims that he will never stop until he proves that I am responsible. Well, here we are, almost 6 years later, and I'm charged with conspiracy to commit first-degree murder. In order to have a conspiracy, 2 or more people have to make an agreement to commit a crime. There is no such agreement between me and my brother Alex, although I did love my brother Alex.
And I'm going to object again, Your Honor, to testifying.
Sustained.
There is no agreement that was shown to you between myself and Melanie Boudreaux, although I love Melanie.
And I'm going to object again to testifying.
Sustained.
I cannot tell you what happened that day on October 2nd, 2019, because I was not there.
And I'm going to again object to testifying, and please strike everything the defendant has said.
All right. The defendant is admonished, you cannot argue things that were not admitted into evidence.
The prosecutor wasn't there. Law enforcement wasn't there. Only Brandon knows what happened before he called 911. Only Brandon said he will not stop. The fact that I supported Melanie in her time of need does not make me against Brandon. I had nothing to gain by Brandon being hurt. Brandon has worked with law enforcement for almost 6 years to make sure that I pay a consequence.
I'm going to object to misstating the evidence.
Sustained. The jury will determine what the evidence did and did not show.
Your job is to determine if I committed a crime, this crime, a conspiracy, an agreement, not cleaning out a garage, but an agreement to commit murder. You did not see an agreement. You did not hear an agreement. You heard Detective Duncan say that he had spent hundreds of hours going over my iCloud accounts. They have 19 years of my accounts, text messages,
And I'm going to
calls.
object to misstates the evidence and no.
If there was an agreement.
Hold on. The objection sustained. The jury is reminded that they will determine what the evidence did and did not show. Go ahead.
If there was an agreement, they would have showed it to you. There is no agreement. We've all experienced tragedies in our lives, and naturally people want someone to blame, someone to pay a price. My brother is no longer here. We can't ask him about that day. There were things presented in this case that I did not know.
And I'm going to object again to testifying, Your Honor, and ask to strike.
Sustained.
Things that I saw, I thought.
And again, I'm going to already ask to strike.
All right. The defendant cannot testify to things that were not testified to from the witness stand.
Because this is the theory the prosecutor wants you to see, it is limited. How can we say clearly when the law only allows for a skewed view of things? The devastation this family has gone through is the tragedy. After almost 6 years, it's time for healing. Thank you.
State wish to give a rebuttal, please.
Thank you.
All right. The state has the burden to prove the defendant guilty, and since they have that burden, they have the right to open and close the argument. Go ahead.
Defendant wants you to think that Brandon has it out for her. She has tried to insinuate that Brandon was involved with working with Detective Pillar for years just to get her. But what you heard was that Brandon has actually been working with law enforcement on multiple investigations. And that in fact, Melanie Boudreaux is a subject of multiple investigations. So again, as the defendant sits up here and tries to portray and paint a picture for you of her innocence and sadness and family tragedy, she again misrepresents what was told to you at trial. She tells you there was no plan, but she ignores the facts and the evidence of a very obvious long plan. A plan that started when she began, this defendant, Lori Vallow, meddling in Melanie and Brandon's marriage. And when that marriage was finally ending, this defendant continued to help her niece, Melanie. She continued to aid her. And what we see in every one of these bits of evidence is this core group of people. This defendant, her brother Alex, Melanie Boudreaux, and Chad Daybell. The four of them working together. Do we need to have words, a video? No, we do not. That is why there is that jury instruction on direct and circumstantial evidence, because you look at what is going on here and it screams to you a conspiracy by this defendant, by Melanie Boudreaux, by Alex Cox, and by Chad Daybell to kill Brandon Boudreaux. Every action you see there, the defendant would like you to look at them individually and pretend that they don't all point to what happened on October 2nd. But everything they did leading up to then shows you a way to cover up and prepare for the murder of Brandon Boudreaux. When we talk about a plan and this defendant's actions, the most obvious and screaming piece of information is this defendant holding on to her brother's phone for days, holding on to the 480-351-9120 number for days while her brother is gone with her Jeep, without the rear tire, without the back seat, with a gun with him. That is part of the plan. That is the assisting, that is the promoting, that is the conspiracy that this defendant wants you to pretend doesn't exist. We don't need words. We have actions that are obvious, and they're done by this defendant and her co-conspirators. The state asks you to look at everything together, regardless of how many people want to cry up here, regardless of how many people want to try to testify. This is not evidence. What is evidence is what was presented to you in trial, and each piece of that tells you this defendant is guilty. And so I ask you to find her guilty of the conspiracy to commit murder against Brandon Boudreaux. Thank you.
All right, members of the jury, the case is going to be submitted to you shortly, but first we're going to draw our alternate jurors. Again, we have extra jurors just in case someone becomes sick or is unable to proceed. So we're going to call 3 alternate jurors. If you are an alternate juror, it may be disappointing to get to this stage in the trial and not be in the deliberation process, but I have in the past had to call back an alternate juror to come back in the jury room when a juror is unable to proceed. So the admonition would still apply to you until we call you and let you know that you're excused. If I don't see you again as far as an alternate, I want to thank you for participating in this process. We couldn't have done it without you. Now we're going to use our very scientific method and draw numbers out of a hat here. Juror 3, you're our first alternate. We're going to draw another.
16.
16. Okay, and
7.
jurors 3, 7, and 16. 7. Okay. I'll come back and talk to you in a few moments before you go, but please, the admonition still applies. I have had to call alternates back. Again, I thank you for your service in this matter. We're going to swear in my staff, the staff that I have so far. My Jay is on vacation this week, so go ahead.
Do you swear that you will take charge of this jury and protect their deliberations from all outside interference and communication? And when they have reached a verdict, you will bring them back into court without revealing their verdict to anyone, so help you God? I do.
All right. The jury is excused at this time to begin their deliberations.
All right, jury.
All right, please be seated. The jury is no longer present. I'm going to put everyone on notice that it would be the court's intent to take a verdict within about 20 to 25 minutes of being notified that the jury has a verdict. So if you want to be present for that verdict, I would advise everyone to stay within about 20 minutes of the courthouse. In other words, in the immediate downtown area. The state has filed an allegation of aggravating circumstances back in January of 2024. One of those aggravators is essentially kind of an overlap with the finding of dangerousness. What other aggravators would the state intend on proceeding with if there were a guilty verdict?
Your Honor, we could just prove the dangerous allegation and accomplice. That would be sufficient.
Okay. Last time we discussed this issue, the defendant was requesting a probable cause hearing, but also indicated that she didn't want to have an aggravating factors hearing. So let me ask the defendant, last time you admitted aggravators, I don't know what your intent is on this time around.
I would object to the aggravating. Of course, I would object to it. I asked for a 13.5 hearing on it so that those aggravators could have probable cause. If you're going to go forward with them, then I will stipulate to them.
All right. Well, the court, I don't think you're entitled to a probable cause hearing, but based on the evidence that was admitted, the court would find that there's probable cause been established that this was a dangerous offense and that there was the presence of an accomplice. I'll go ahead and prepare the instructions just in case, and then we'll see what the jury does. Please make sure that my assistant has the necessary contact information for everyone. But again, I would ask people to stay within 20 minutes of the courthouse. All right, thank you.
Well, so here we are. And it looks like I'm trying to read the, I can put up the, let's see. Let's see what Justin is. Hang on, y'all.
Through this randomizer of choosing the alternates. 3 were chosen as alternates. 2 of them were men, 1 woman. They could be called on if anything happens. Is now jury deliberation went on for about 15 to 17 minutes. We were clocking that as they entered the deliberation room. They may not even have really gone over anything at all and just decided, okay, who is our 4-person? Do we want to stay here this afternoon into the evening and get this done, or do we want to come back tomorrow refreshed? They ultimately decided that they were going to go home for the day, come back tomorrow at 10 in the morning. So we will be, continuing that clock for Verdict Watch tomorrow morning. We will be streaming right here from Fox 10 Studios for coverage of the Doomsday murder trial, the final chapter. But you heard closing arguments there, very short from Lori. She got emotional, whether you buy it or not. She said that she did not make an agreement with her brother, Alex Cox, at all, and that this was not a conspiracy. She once again calls this a family tragedy. She goes back to the date of June 25th, 2019, saying that at that time, Brandon was going to prove to everyone that she was responsible for the ending of his marriage with Melanie Boudreaux because of the misinformation that had come out to his wife at the time, that he had hacked Lori's computer, that he was gay, multiple things that were just not sitting right with the family, very much a family drama. She gets emotional then, saying, she's sorry he feels this way. There were so many objections that we heard by the state, objecting to her talking about character evidence, appearing to testify through her closing arguments. We have seen this pattern before. She did not have any witnesses to call. She's not going to put herself on the stand and open herself up to cross-exam by Trina Kay. So this is really the last-ditch Hail Mary. Trina Kay did do a very thorough job of presenting this PowerPoint, going for almost an hour and listing everything that Lori has done in this timeline that promotes and aids a conspiracy. Whether she knew what Alex Cox, her brother, was going to do that day, it is the burner phones that were being purchased. It is the storage unit where the tire in the back seat is stored. It is the calls that were made after Alex drove off out of that neighborhood after Brandon Boudreaux was shot at, after he allegedly opened fire on him as he arrived in his driveway in Gilbert on October 2nd, 2019. So what do you all think? You have all been watching this entire case closely in this trial. Was there enough for the state to prove that there's a conspiracy to commit murder? Now, just 15 to 20 minutes ago, whatever it was, I called the court spokesperson and he told me they're coming back tomorrow morning. I almost had to double take and say, wait a minute, they're coming back tomorrow, or is a verdict in? That would be so unbelievable and hard to believe, to fathom that a verdict was in that fast. But he reconfirmed, yeah, they're going home for the day after hearing all of that testimony, especially from Nick Ballance. It gets very technical regarding cell phone data, and then going through some long closing arguments, specifically from Trina Kay. It's like you're hearing the case all over again in order chronologically, and how the state is trying to make sure that the jury instructions are understood. The judge also going over the jury instructions. So it has been a long day. It really has only been 5 days of trial. And I think, the jury says, well, we are doing our duty. We get paid for our duty as well. There's no need to rush this. This is definitely a serious case. Let's go home. Let's get refreshed, recharged, and tomorrow morning we'll get back to it at 10 a.m. Meanwhile, we're getting ready for our coverage of this case that goes on our newscast as well. We have nearly 2,000 of you watching, looking out for questions. The chat box is blowing up here. George is working on producing our shows as well, juggling multiple tasks. How are we looking? And I guess since you're going through all this sound, there's got to be sound bites that are standing out to you that we're going to be using later on.
Well, I will say what I'm noticing is as we were following the closing arguments, kind of a stark contrast from what we saw earlier in the morning. A lot of technical, stuff, a lot of, a lot of graphs, a lot of maps, a lot of data being thrown at the jury. Then you flip the script. Trina Kay comes out with her closing arguments and really kind of hammers home the conspiracy part at the end of all of this. And then in her rebuttal to the closing argument from Lori, hammers home again that, look, this is the conspiracy angle. And this is what you have to convict on. And this is, this is her role, this meaning Lori. This was her role in the conspiracy. obviously closing arguments are kind of the Cliff Notes version of the case that was just presented, right? That's the point. You kind of just put a bow on it. And I thought it was much more concise in how she delivered that to the jury, kind of lining up again. She had kind of laid out the dots over the last week, but then in her closing arguments, she took all those dots again and really kind of compressed them down and made them, I think, understandable to the jury, kind of reminding them, look, this is kind of what I was laying out, and this is how you should read into what I just presented to you over the last week. I also, want to point out, I think I did earlier too, that what we learned in the last trial from the jury was that they took a lot out of the fact that Lori didn't present a case. Aside from the facts that were presented in court, the last jury in the last case said, look, we found it pretty shocking that she didn't present any sort of defense, right? And so you have to wonder if this jury is thinking the same thing. We have argued that this case, at least our panel did earlier, which I somewhat agree with. This case is the one case where she could potentially, be acquitted on because they don't have as much direct evidence to point her as being the one, maybe the ringleader in all of this. We know from all the other cases that, that this in a roundabout way, she kind of was the ringleader, her and Chad. But yeah,
definitely. And they were 50-50 in that part.
Right.
I mean, they have been convicted in Idaho. It is the same case. The Idaho case is the largest.
Right.
And then you take this Gilbert case and it's a piece of the pie in here in that case. So in our world, in the overall general topic of this, we know she's a convicted murderer, and that we know the motive now. The jury doesn't necessarily fully understand the motive of this incident on October 2nd, 2019, but all they need to do is answer the question yes or no. Did she do anything that promoted what happened? Did she allow this to happen by her actions, regardless of what she knew in detail? Because we know, we haven't read text messages for this trial. We haven't heard phone calls and recordings.
Well, that was the challenge. We knew there was a lot of overlapping evidence with all these cases kind of intertwined that wasn't going to be admissible, that was kind of left open. But then you also have, Lori, there was also evidence that maybe could have been presented that wasn't. Look, the previous trial, Trina Kay didn't call all of her witnesses. This case, she didn't call all of the witnesses she planned to. Not that any of that evidence would have mattered anyway. We don't really know, but we do know that there's stuff that wasn't included in this trial that would have alluded to more to the dark and light spirit kind of talk that we heard in these previous cases. But I guess we'll find out if that makes a difference. How much do we read into how quickly they come to a decision? Do they come back? Does the foreman come back tomorrow with questions? If we find out that we get to the lunch break, and they haven't made a decision, what do we read into that? Do they take longer than the last jury? So we're not going to have much. Obviously, we're not going to have anything going on in court tomorrow for the most part. But it'll be interesting to see if that gives us, again, the litmus test of whether or not the jury is still mulling their decision. Because, I mean, what are we, 3, 4, 5 days almost of testimony? That's it. I mean, we could get a
18
verdict
witnesses
around the same time that we
days.
got opening arguments this time last week.
Yeah, basically taking a week or so. If jury deliberations goes past tomorrow, then you're looking at a possible hung jury, right? If it's lasting a whole day,
that
8
would be my
hours.
lead. Yes, that's
right?
how I would read it. Right. I think our panel would agree that they're still, that they're debating amongst themselves again about whether or not there's enough there for the conspiracy charge. And then we can talk about whether putting Ballance on the stand last was the right decision, whether Detective Hermosillo from yesterday should have been the last witness. I still think very strong witnesses, but then also, ironically, is it the fact that Lori didn't have a defense? Did that help her? Because again, she fell back into that trap that she did in the last trial with her closing arguments, where it came across as she was testifying. Trina Kay had several objections, like she did in the last closing argument.
Riddled with objections. Yeah. This closing argument. I mean, it didn't last very long, it got emotional and it did sound like testimony.
Yeah, and that struck us too, that she's very emotional and tearing up in this closing argument, but we didn't see that from her in her closing arguments in the Charles Vallow case. So, there'll have plenty to talk about, obviously, as we get closer to this decision. But we're going through the bites here. I'm listening. I would argue this was a better closing argument in this case than previously. But again, with with not having as much directional evidence to tie Lori to this, I think Trina realized, look, I've done all I can here with what I was, given, and the burden of proof and all that she was short and sweet and to the point.
Trina's rebuttal, I felt, was even stronger than the closing argument.
Yes.
The closing argument, you have a lot of information to boil down and condense and break it down in order and whatnot, and you're presenting this PowerPoint presentation basically to sum up all the facts and the evidence to the jury. But the rebuttal, to go after Lori and say, you can cry up here, do whatever you want, but the bottom line is this is not a family tragedy. There was a clear conspiracy. There was an alibi created with the burner phones, the real phones, and she is not afraid of mentioning Melanie Pawlowski. I would love to know what Melanie Pawlowski is thinking right now, because she has been considered a suspect in this investigation, still an open investigation. No charges have been recommended at this point that we know of, and we can check on that right now. We could ask Gilbert PD if they've recommended charges to the county attorney's office, because they never did for her. They only did for Chad Daybell, and the MCAO said, no, we're not going to prosecute. But this looks bad on the part of Brandon's ex-wife as well, and it does make you wonder, as everyone is asking, as Melanie's name is brought up again and again and again, will she be charged in this case?
Yeah, we were surprised when we heard her name brought up by Trina Kay outside of the jury at that time, that that Melanie is still being investigated in this case. The first time we had heard that, she brought it up again today. We wondered whether were investigators in Gilbert waiting for this trial to play out to see if there was evidence they could use in their investigation. I wonder if there was enough out of this. I mean, there was a lot about phone calls today between Melanie's phone and Lori's phone on October 2nd. Even prior to that, was that Melanie relaying to Lori where Brandon was? Again, they don't have recorded phone calls between these two talking about it. And as far as we know, there's no emails or texts that say, yeah, hey, Lori, here's, Brandon's new address. Maybe investigators have that and we haven't seen it, but the fact that it's still open 6 years later, almost 6 years, 5.5 years later, I'm kind of surprised by that. And I guess we'll wait and see. So is there a sixth trial or whatever? It's hard to tell now.
Oh man, let's not talk about any of the trials, but we did get through this one quick. This trial is basically, we are just waiting on a verdict now. Lori, also important to note, objected to the aggravation phase. If she's found guilty in this case, again, she doesn't believe that there should be aggravating factors. She's already serving life in prison for the Idaho convictions.
Yeah.
So again, stipulating to the aggravators. And so if she's found guilty, she'll have her sentencing for this case, just like she'll have her sentencing for the conspiracy in the murder of Charles Vallow at some point this summer, you can assume. And then after sentencing, she would return to jail, or maybe she would be transitioned to the Department of Corrections in Arizona for a little bit and housed there. And then Idaho will call, for its extradition. State of Idaho will call for extradition, bring her back to Pocatello Women's Correctional Center, and she'll serve this the life's terms for killing J.J. Vallow, Tylee Ryan, and conspiring in Tammy Daybell's murder. So that will happen. That is inevitable. The question is, how much longer does she stay at the Estrella jail here in Arizona?
Yeah. You wonder how long?
It's all on extradition logistics and all of that. And
yes, and the appeals.
Maricopa County Sheriff's Office and when they can get her back to Idaho. It will happen whether or not she's found guilty in this case. We're just waiting for this case to be finished, and then sentencing will happen.
Do you think, again, victim impact statement, anything like that? We know Brandon had a lot to say on the stand. He's the only surviving victim. So, we've heard from I think Tammy Daybell's family in the Idaho trial. So we've heard.
Oh
from the-
yeah, everyone affected.
Yeah.
It
So
was
that'll be interesting. Again, Brandon's had his opportunity to confront Lori. Obviously, she cross-examined, but
well, yeah, if she's found guilty in this case and at sentencing, I would fully expect victim impact statements by Brandon Boudreaux, who gets to not only speak for himself, but he gets to speak for everyone. If he does it and doesn't, she's already convicted at that point. I don't know if it opens the door and he's allowed to talk about JJ. He's allowed to talk about Ty Lee. He's allowed to talk about Tammy, Charles. I don't know what that victim impact statement will look like, but I think more important, the priority and focus for him, get that off his chest to the person who is right now accused of doing this, innocent until proven guilty. We still do not have a verdict yet. But if that happens, if she's found guilty, there will be a lot to say. All right, so this is the plan. We got 2,000 of you watching. We're about an hour and a half away from our newscast, and we've got to get our on the record nightly recap ready for you guys as well. So a lot more talking to do, but the plan is I'm talking to the panel right now on the group chat, and tomorrow morning at 10 a.m. we want to be back here streaming with our verdict watch clock on the screen, so you see how many minutes have elapsed and how long the jury has been deliberating, and we'll be waiting for the news that the verdict is in. And also, we will check in to see if that verdict will be read on a 5-minute delay or the 30-minute delay, or will it be live? I don't think it will be live, but it was a 5-minute delay on the last verdict regarding Charles Vallow's murder. But we'll be streaming, we'll be talking, we'll be, running old clips. We'll really be just here to talk with you all and answer questions until we get word that there is a verdict. We'll take some breaks, but we will be streaming. That is for sure. So you do want to be here. Make sure that you subscribe to our notifications for our live streams. We'll most likely be on Fox 10 Talks as well, talking.
Okay. See, is my mic? Oh, there's my mic. Okay, y'all. What a day we have had. What a day we have had. Been on here for 5 hours and 23 minutes. The deliberation, I guess I should put it tomorrow. We're going to start at 10:30, or that's when they're going to start deliberating at 10:30. So I guess we don't necessarily have to be here then, because I guess there will be a 20-minute delay, because once they come out, we will. Let's see. I'm trying to see. Yeah, y'all be sure and set that little bell so that it will tell y'all when Kresha's going to be back. Like I said, I'm not sure if she's coming back tonight. But I have put a well, not sure what I did. Okay. Sure to decide what it did this. So what we're gonna try is so they are scared. They went and hid the tire seat after they checked the storage unit. I guess that I hadn't thought of that. Like after they figured out that they had missed him, they got that tire and stuff out of the house in case the police came straight over there. She is such a. All right. Lord have mercy. No sound on my. Well, Susan Honecker, I hope you're the only one that has that. But the jury went home. No, the jury went home, zero. They've gone home, and they're going to get a good night's sleep. And they're coming back tomorrow morning and starting at 10:30 Arizona time. That'll be 12:30 Central Time. I'll do your math. And so it will be sometime, because they're going to have time to deliver at least 30 minutes. So I would say that we probably will be on by lunchtime. By lunchtime, there or here, either one. In a couple of hours, they have to be ready. So that would be a couple of hours there would be 12:30. A couple of hours here would be 2:30. So we'll probably get on in the morning and be ready. So I want to say justice for Tylee and JJ, Brandon, Charles, also Joe Ryan, Tammy, and all the other people that these awful people committed things against them. Yes, we're going to meet here at 10:45 in the morning. That sounds good. I'm going to start a video and we'll see you in the morning. So I'm going to say goodnight and remember to let's try to get justice through understanding and love always wins.